All right, thank you. Mr. DeSalen, I see you at the podium. We are.
I cannot hear Mr. DeSalen.
Oh, turn the mic on.
Thanks, Kelsey. Can you hear me now? Hello? Can you hear me?
Yes, sir. Yes, sir.
All right. Thank you, Mr. Lee. Thank you, Madam Hearing Officer. Charles DeSalen, representing Coalition for Clean Affordable Energy. Before we get started, I just have a very quick procedural matter that I want to raise with you. Normally the record closes at the end of the hearing. And I know that sometimes you will allow the record to stay open for the submittal of public comments for a week or two after the hearing. And I know we're on a tight schedule here, but I know there are some members of the public that would like a little bit more time to submit written comments. And so I would request that you keep the record open for another week after the hearing is over.
Okay. I don't know that we usually do a week. It's usually a matter of hours or maybe a day. But Ms. Sona, what say you?
Madam Hearing Officer, I think a week would be difficult given that the parties have to get their closing and all of that. And so to have to review what could be more information in the record in just a matter of days could be very challenging given the tight time constraints we're under. Maybe leaving it open till Monday or something would be okay, but I think a full week would be challenging for everyone.
Any other thoughts on this? All right. Then how about by the end of day, November 24th? That is Monday.
Madam Hearing Officer, excuse me, Madam
Yes.
Hearing Officer, I had raised my hand. I don't know.
Who is speaking?
This is Bruce Weatherby. Yeah.
Can you hear me okay?
Yes, go ahead.
Yeah, I wanted to suggest that I understand people are concerned about time constraints, but public's involvement is important, and I think a compromise between Monday and a week is probably a fair way to look at it. And I would argue, or not so much argue, but encourage that to be an option. Thank you.
All right, thank you. Any other thoughts on this? Again, we've been in hearing for a long time. Ordinarily, we would be closing the record at about 5 o'clock tomorrow, right? I mean, that would be the last day of hearing and the last day that public comments could be submitted. So we're ending, it appears anyway, a day early. But I think it's been a long window when people could actually submit comment. Let's do Monday. It's November 24th, anytime then. And Pam will have them, Pam or Luis will put up on the docketed matters page, whatever you receive then on Tuesday. Yes, by the 25th? Okay. All right, thank you. So then everyone will know what's been received, because that also takes some time to get them all collated and up onto the docketed matters page. Okay.
Madam,
Yes, Ms. Sona.
could Ms. Jones send an email to all the parties when she's completed uploading everything so we have some certainty when we'll go look at it and know we've captured everything?
Pam, would you add that to your list?
Thank you so much.
Okay. Thank you for raising that, Mr. DeSalen.
Okay, sure thing. Thank you, Madam Hearing Officer.
Any other preliminary matters? Shall we go back to the questioning of the department panel by Ms. Olson?
Yeah, and Sorry, just one follow-up point on that last conversation. You're talking about closing, taking evidence, but you'll leave the record open to accept post-hearing submittals.
That's a different discussion.
Okay,
Yeah, I'm not talking about closing argument by Monday. He's asking about public comment.
right. Under the
Non-technical.
rule, it just talks about the record, so I just wanted to make sure that we're all on the same page that the record isn't closing.
The record is closing Monday because that will be the evidence. The closing argument that comes in sometime subsequent to that is not evidence, it's closing argument.
Okay, sorry, I think I have a different understanding of the record definition, but I'm clear on that. Thank you.
All right. So I think you were done with Mr. Vaughn, but you still have time with Dr. Rasso and Ms. Borchert. Go ahead.
Okay, thank you. Good morning, Dr. Rasso. I'd like to start with you if that's okay. And I'm going to focus this morning on your energy economy ratio value testimony. So just hopefully we can start on a point of agreement. The purpose of the CTFP is to reduce carbon intensity of transportation fuels used in New Mexico. Do you agree with that?
That is the purpose of this rule. Yes.
And I'm going to start with page 1 of your rebuttal. And I understand you're contending that the energy economy ratios place all fuels and vehicles on a common basis.
That's correct.
And I also understand you to be claiming that energy economy ratios do this by calculating carbon emissions per mile traveled. Am I understanding that?
Give me one moment to review exactly what I wrote.
Sure.
Yes, I wrote places all fuels and vehicles on a common basis by calculating carbon emissions per mile traveled.
Okay. And then I think your other statement is carbon emissions per mile traveled is the best indicator of a fuel's total life cycle emissions and global warming potential. Am I understanding that correctly?
That is what is in my testimony.
Okay. And understanding what an energy economy ratio is, if we compare to like what's on an electric vehicle sticker, an electric vehicle window sticker when you're buying a new EV provides a stated range that's predicting the miles an electric vehicle will travel per kilowatt hours of fuel. Is that accurate?
I'm not remembering the details of what's on window stickers for when you buy an EV.
Okay, then are you familiar with ranges for an electric vehicle?
Do you mean ranges like how far a vehicle can travel on a full charge?
Right.
I'm generally familiar, yes.
And are those calculated by dividing the miles traveled by kilowatt hours of fuel?
I'm not certain of the exact calculation for those.
Okay, so you don't know how efficiency of energy efficiency of an electric vehicle is calculated?
That's not what I stated. I stated that I don't know how the EPA rated range of electric vehicles is calculated.
Okay, what is your understanding of how efficiency or a range of electric vehicle is calculated?
I believe it's based on the test cycle data, but I think that's about as far as my familiarity goes.
Okay. So let's see, turning to page 2, I think I understand your contention to be that excluding energy economy ratios from the CTFP would cut the fuel life cycle to the amount of energy delivered to the vehicle and would not include the full use of the vehicle, or excuse me, would not include the full use of the fuel by the final consumer. Is that accurately stating your testimony?
I believe so.
The department's not suggesting there's a way to track or account for the actual fuel use of the fuel by the end user, is it?
Objection vague as to which fuel.
Just rephrase.
Well, your testimony is that economy emissions per mile travel is the best indicator of a fuel's total life cycle emissions and global warming. You confirm that statement. And then your testimony is if you exclude EERs, you would cut the fuel life cycle to the amount of energy delivered, the amount of energy delivered to the vehicle, and you would not include the full use of the fuel by the final consumer. You confirmed that was your testimony. And now I'm asking, the department's not suggesting there's a way to track or account for the actual full use of the fuel by the end user.
I think I'm suggesting that the statute in the definition of fuel life cycle requires that the fuel life cycle include use of the finished fuel by the consumer.
Okay, so in your testimony, when you're saying your concern is it would not include the full use of the fuel by the final consumer, are you suggesting the department's trying to track or account for the actual full use of the fuel by the end user?
I'm sorry, I'm a little confused. I feel like I maybe already answered that. The definition of fuel life cycle in the statute includes use of the finished fuel by the consumer.
Okay, can you point me to the language of the statute that says use of the full fuel by the final consumer?
Give me 1 second to get the statute. And, I apologize, I didn't put the citation for the statute in my written testimony, but the quote on page 2 is directly from the statute.
Would it,
It's in the definitions. Do you have the definitions? So 74-1-3D is the definition of fuel life cycle. It reads, fuel life cycle means an assessment of the aggregate greenhouse gas emissions based on science-based models or protocols, including direct emissions and significant indirect emissions from indirect land use change, all stages of fuel and feedstock production and distribution, feedstock generation or extraction through the distribution, delivery, and use of the finished fuel by the consumer, including consideration of storage, transportation, and combustion.
okay. Thank you for that clarification. And bear with me while I'm continuing to try to understand the department's position on this. So if the energy economy ratio is driven by the final consumer, is that the user of the vehicle?
I believe that the consumer typically would be the user of a vehicle, yes.
And so would you agree with me that the user of the vehicle or the driver can impact the actual efficiency of how that fuel is used within the vehicle?
Yes, I believe that driving technique plays a role in fuel economy.
And would you agree that tires on a vehicle also play a role in energy efficiency of the vehicle?
I am not sure about that one.
Okay. What about maintenance of a vehicle?
Um, I couldn't exactly speak to that. I'm sorry.
Okay. And with electric vehicles specifically, are you familiar with whether things like whether regenerative braking is turned on or off, and the speed at which the vehicle is driven would influence the efficiency of that vehicle?
I'm unaware of any electric vehicles that allow you to turn off regenerative braking entirely. I would agree that use of heating and cooling systems due to weather, and I'm sorry, I forgot what the last one you listed was.
The speed at which the vehicle is driven.
Speed plays a role in fuel efficiency for all vehicles.
Okay. And so if the driver of the vehicle is influencing the ultimate efficiency of the vehicle, the department wouldn't consider approving multiple energy economy ratios for the same vehicle type based on representations by the end user of that vehicle, would they?
I'm sorry, could you repeat that question?
Sure. We were talking about how the driver influences efficiency within the same vehicle, but the department would not. So my question for you is, the department wouldn't consider approving multiple EER values for the same vehicle type based on representations by the end user and how that vehicle will be operated?
I think a lot of this goes back to the discussion we were having earlier, and I think I got a little confused when talking about EV stickers and how those values are calculated. But EERs, the EERs in the rule, and the EERs the department is going to calculate for residential EV charging are based on EPA rated vehicle efficiency. Those EPA vehicle efficiencies are based on what I referred to as test cycles. Essentially, automakers, when they are getting their vehicles approved, go through test cycles that are designed to be representative of typical driving. And some of these test cycles can also include extreme driving situations. Not only EPA has test cycles, CARB also has their own test cycles, and they try to align them for ease for the auto manufacturers. But one of the things I've heard discussion of is cold weather test cycles, and those being included into those range or mile per gallon equivalent test cycle calculations. So the EER is being based on mile per gallon calculations, which are based on test cycles, I think already effectively accounts for the variables you're bringing up.
Okay, so I think if I'm understanding you correctly, the EERs aren't intended to account for the actual full use of fuel in the vehicle. Instead, it reflects modeled vehicle fuel efficiency based on assumptions or averages about how the fuel could be used in the vehicle. Is that accurate?
They're based on actual data that is based on test cycles, which are designed to be representative of real world use.
Across an average, though, not actual use in a specific vehicle.
The test cycles are performed on specific vehicles.
Right. I think the disconnect is the value that you all have selected is not based on the use in a specific vehicle. It's based on aggregated data. Is that accurate?
I would say it was representative of average use.
Okay. And with respect to electricity, is it also representative of average mix of fuels that would have generated that electricity?
So the EER does, I'm a little confused by your question. Maybe you can rephrase it?
Sure. So when we're looking at the EER values for electricity and how electricity is used in a vehicle, there's no distinction between renewable generated electricity or fossil fuel generated electricity. Both of those are factored in to a single EER value. Is that accurate?
The fuel used to generate electricity is not included in the EER. The EER accounts for the how efficiently the vehicle uses the fuel. The accounting for different types of electricity generation, renewable, natural gas, coal, comes in when the department calculates the electric distribution utility carbon intensities.
Okay. So would you agree with me that the adder for EER values can be provided even if electric energy is generated by coal?
I would dispute the wording of adder, I think, but I would agree that if a EV was charged from an electric distribution utility that sourced its electricity only from coal, we would still apply the EER when calculating credits.
Okay.
And I might add to that, there is no utilities in New Mexico that source their electricity only from coal.
Would you be surprised to find out that may not be true?
I would be very surprised.
Or only from coal? Okay.
Only
I
from
understand
coal.
what you're saying.
There are utilities in New Mexico who source some of their electricity from coal, just
Understood.
not only.
Thank you. Sorry, I missed that.
Mhm.
Would you wrap
distinction.
up your questions of Dr. Rasso, please?
Yes. So the final questions I have for you is another concern you have about removing EERS would make New Mexico an outlier among CTFP programs or similar programs?
It would make New Mexico unique.
Okay. And if I understand your testimony correctly, I think you agree that New Mexico may be unique in the wording of the statute, but that other states consider the concept of technology neutrality in forming their regulations?
That's correct. You know, specifically, I, in preparing my rebuttal testimony, reviewed the California Air Resources Board initial statement of reasons from when they adopted the LCFS program originally. And I came across an answer to a question they had answered about EERs, and they specifically referenced EERs as them considering them as technology neutral in their answer. So other states definitely have considered technology neutrality in general and specifically as it relates to EERs.
Thank you, Dr. Rosso. I appreciate your time this morning. And now, Bureau Chief Borchard, I'd like to move on to some questions to you. In the remaining time, I'm hoping to perhaps ease the work of the board by exploring a couple areas with you to gain clarity on some of the department's proposed language, and also briefly explore whether we may be closer to potential agreements. So I'm going to start with probably your favorite topic, program timeline. On page 2, I think your testimony is delaying the effective date by 2 months allows the program and regulated parties 2 additional months to prepare for implementation of the program. Is that accurate?
Yes, that is accurate.
And I don't envy the department having undertaken the effort to try to go through all of the comments, proposals, and feedback you have received in this process. But from a high level, would you recognize that some of the regulated community that will be participants in this program have raised concerns based on experience with other programs, that even with that 2-month extension, the proposed implementation timeline does not allow sufficient time to establish a functional market?
I am aware that some of the witnesses have expressed that opinion. And I think it's also important to note that I haven't been given any concrete evidence on that statement.
Okay. You've heard concerns presented in this case regarding availability of biodiesel or renewable diesel to meet New Mexico's CTFP demands, correct?
No, that is not correct.
So you're not aware of industry concerns about whether biodiesel or renewable diesel will be available in quantities to meet the CTFP demands? And I'm sorry, I'm not badgering. I just want to make sure I understood your question. Your
Yeah,
answer.
that's correct.
Okay. And I think member Ely raised this earlier. Is the department aware or recognize that there will be competing demands for any renewable fuels that may be available nationally?
Objection, Madam Hearing Officer. We had a whole panel yesterday that talked about this topic. This isn't within the scope of Bureau Chief Borchardt's testimony regarding implementation.
Right. I don't remember that it was. Am I wrong about that, Ms. Borchert?
Yeah, I did not speak to the availability of biofuels in New Mexico based on the national market.
Madam Hearing Officer, with all due respect, I think I understand Ms. Borchard as the Bureau Chief to be the ultimate witness who's supporting the department's implementation timeline. And I'm exploring the assumptions that are going into the Bureau's pushback and consideration of factors that went into her testimony that a 2-month implementation start date is appropriate. And I think it's very important for the board to consider the factors that went into that so that they can reasonably assess whether that's an appropriate implementation schedule.
So, Ms. Borchard, I trust that as the chief of the CTFP team, that you are aware of the assumptions made by the panel from yesterday and have some understanding of the implementation timeline. If there's something you can say about that based on your understanding of your team's testimony from yesterday, that's great. But to the extent this really is about their testimony, other than assuming that what they said was true and that you agree with it, just draw those lines if you would.
Yeah, I mean, I was listening very carefully to our panel yesterday and some of the questions that came from the board. And I believe, I mean, I could only say that yes, our evidence, our modeling, and the timeline as presented in the rules is all based on the understanding that indeed there is adequate, the feasibility of our timeline has been demonstrated by 2 models, bookending, and they both show that regardless, you know, the actual future, what it'll look like will be some combination not represented by any of those models, but in the middle of the world presented, and our modeling demonstrates that indeed this timeline is doable.
So maybe if I put it in more of a policy question, and I'm not trying to repeat myself, I'm trying to truly explore whether or not there's a common understanding here. If there are challenges with the availability of renewable fuels, do you agree that that could impact the feasibility of CTFP compliance in the immediate term?
Same objection, and I'd request the same caution, please.
All right, Ms. Borchert, you understand the caution, I'm sure.
Yeah, I have no basis on which to think that the fuels that are required for this program won't be available.
What happens if those fuels are not available to satisfy the feasibility of the CTFP program?
You know, the deferral program section of the rule addresses that, right? So by October, I believe, or maybe November, I'd have to double check, of next year will be when we get the first fuel forecast report, right? And by then we will have had some indication of what both the deficit, what the fuel, the deficit generating fuels are going to be that come into the state, as well as the clean fuels. We'll know a lot more about the credits generated by all the EVs that are in the state, and we'll also, I believe, have a contract with a backstop aggregator whose job it will be is to make sure all the credits that are available in the state are brought to bear. So it's you know, it's a question that doesn't that I don't really feel like we can explore any further than we already have in all of our extensive modeling, where we've thought about all these possibilities and we have tried to tie in the pieces into the whole as represented by our rule.
So if I understand your testimony, the department has undertaken several efforts to predict what's going to happen, and the uncertainty can be addressed later depending on how things actually play out. Is that fair?
Maybe I would say it slightly differently, which is there are safeguards in place, including deferral, should that be needed. We don't expect it to be needed, but it, you know, we have considered what happens should the future not play out in the general realm in which we have modeled and expected to.
And the deferral system in place is subject to the department's sole discretion. Is that accurate?
No, I don't think that is. I think that would probably be a question for Mr. Vaughn, but he read the section of, I believe it's 602 yesterday, where there is an automatic, if the deferral, if the report done by an independent state agency, NMDOT, shows up with certain deficiencies between the expected credit generation and the expected deficit generation, it requires the department to take certain actions. I don't think there's discretion. I really want you to go back to the testimony of Mr. Vaughn, but I mean, I could either turn to it. I don't want to misspeak. Maybe that's the best approach since Mr. Vaughn's time has already been used up. But I don't think that the department has discretion. It takes action as a result of the emergence of the deferral forecast report.
Okay, if we can either do that subject to check what's in the written testimony, or I am open to however you want to
Well, I think
address
it's,
it.
I think it's up to you. Do you want me to take the time to find the language? It was very clearly read by Mr. Vaughn yesterday. Pardon? Page 83, thank you. So section 601 is off by one. Forecast deferral. Yep. If a transportation fuel supply forecast concludes a credit shortage, meaning the amount of forecasted, generated, and banked credits available during the next compliance year is less than 100% of the credits projected as necessary for registering parties to comply with the CTFS, the department shall issue a forecast deferral declaration.
Okay, thank you for that clarification. I want to change course here and talk briefly about the proposed enforcement rule language. So it looks like you have the rule in front of you. I'm looking specifically at 604C. And I don't want to bog anyone down with the legal details. I think we can brief whether or not the department has administrative compliance enforcement, but I want to explore a couple topics with you in the event that the rule language is adopted. So 604C3D provides an administrative compliance order shall assess a civil penalty for each violation as appropriate. Can you provide any clarification on what as appropriate is intended to mean?
I interpret that to mean on a case-by-case basis.
Okay. The department hasn't identified what a penalty amount that may be appropriate for this program could be in the proposed rule, correct?
Correct.
Is the department relying on any authority that actually states what the civil penalty they could contemplate would be? The actual amount?
Objection, Madam Hearing Officer. To answer that question would require Bureau Chief Borchert seeking counsel from an attorney. And so I do not believe that's within the realm of what a regulator can testify to.
Okay, Ms. Borchard, if you have an answer that doesn't require consultation with an attorney, go ahead.
And Madam Hearing Officer, if I may, I'd like to request clarification on the instruction to ask Ms. Borchard to provide an answer if she can. When my objections are stating that the question calls for a legal conclusion, I'm identifying the concern for the record. And by asking the witness to answer to the best of their ability is difficult because it in fact forces them to put on the record testimony with a response such as I cannot answer, I believe that calls for a legal conclusion, or forces them to testify to knowledge or absence of knowledge when they say, I don't know the answer to that. And so asking them to in fact answer puts them in a very difficult position of testifying under oath still to what is a legal conclusion.
And Madam Hearing Officer, maybe I can just clarify. I'm not seeking a legal conclusion. I'm seeking clarity on the proposed penalties that the department's contemplating in the department's rule proposal. I don't see a penalty amount identified in the text of the rule, and I'm asking the department whether or not there's any documentation that I should be looking elsewhere for what the penalty amount they're suggesting shall be stated
So
in the rule.
No, I understand, Ms. Olson. One answer might be the Bureau is going to craft a penalty policy, for example, and have factors in there that allow for calculation. Just working at ED a long time ago, I remember the bureaus typically had penalty policies, for example. So I think I understand your objection, Ms. Sona, but I also think the bureau chief is a sophisticated witness who might actually be able to offer something helpful without straying into testifying about the law. So, Ms. Borchert, do you remember the question at this point?
Yeah, could you please repeat the question? Thank you.
Yeah, I guess as we sit here today, has the department identified what the penalty amount they could potentially assess would be?
No, we have not.
Thank you. Okay, I want to go briefly to the appeal language that was added in this rule. I think it's the next section, and in the event that these proposed provisions are adopted, I'm wondering if the department would oppose adding language that clarifies or specifies when a hearing is requested, an administrative compliance order would not become final until the administrative hearing process is complete. In other words, the department wouldn't seek to require compliance with the stated penalties or enforcement actions in a compliance order until the hearing process you all have provided for is complete.
I'm not prepared to evaluate that just on its own. So I don't actually know what the process is, but I suggest maybe you add that to your final recommendation, and that will give everybody a chance to look at what you're suggesting.
Sure.
Ms. Olson, this will have to be your wrap up. I did add time, obviously, for the discussion before.
Okay. I just have one additional clarifying question on registration fees, and maybe I can just ask it at a high level. I believe in the compliance section, the department's suggesting that additional enforcement costs could be added to the compliance section, and the fees section also talks about enforcement costs. I think tracking the language of the statute are included in the annual budget, and I'm wondering if those are two different buckets of costs.
Yes, in my opinion, they are.
And can you just briefly explain the difference between those two buckets?
Yeah, the budget that will be set up on an annual basis could include a certain amount for general program compliance. That includes, it would be an act of compliance to review people's compliance reports, for example. That is, in my mind, a part of an annual program fee. If the review of somebody's compliance triggers seeking additional information and a case-by-case need to involve a particular party, that, in my mind, is then a different bucket that could be then rolled into the compliance section.
Okay, thank you for that clarification. Those are all the questions I have. I appreciate all of your time this morning.
Thank you.
Thank you, Ms. Olson. Mr. Tucker, do you have questions of the department panel?
Good morning, Commissioners, Madam Hearing Officer. For the record, my name is Aaron Tucker on behalf of Oxy USA. Good morning, Ms. Borchard. I'd like to start with you. Welcome back. I wanted to start off by acknowledging some of the recent changes that NMAC made to the project credit section. In particular, Oxy appreciates and strongly supports NMAC listing direct air capture and point source capture as eligible projects. Also appreciate the department adding removals to the heading of the section. Thank you for those revisions. But we're not here really to discuss, our points of agreement now. And there are still some places where we disagree. So I'd like to kind of move on to those if that's okay. If you could please turn to NMAC Exhibit 113. This is the NMAC's most recent red line, and just for everyone's benefit, I'll put it on the screen as well. Oh, yeah.
What page?
I'm on page 43. Can everybody see that? I know it's a little small in the room, maybe. Okay. On page 43, beginning at line 10, NMAC proposes new language related to credit generation. This language requires activities and projects can only receive credits for the reduction of greenhouse gas emissions where the reductions are voluntary and additional, correct?
Mm-hmm. Yeah, and I actually think this line of question may be more appropriate for Dr. Rosso, but we can listen to your questions, and then I think it's okay if we just decide amongst ourselves
Okay.
who is best equipped to answer.
Okay, sounds. I'll start my questions, and if it's appropriate for Dr. Rosso, I'll shift over to her if that's okay.
Mm-hmm.
I don't think any of us dispute that reductions should be voluntary and additional, but where we disagree maybe is on the language. NMAC's proposal beginning on line 15 states that that the reduction or removals shall be additional to any greenhouse gas reductions that result from the most stringent of, and then goes on to list 4 potentially applicable categories of laws, correct?
Yes.
Okay. My questions here relate to the language that result from. Do you believe that language is clear?
Any additional greenhouse gas emissions reductions that result from. Yeah, sounds like you have an answer.
I believe the language is clear. If you'd like the bureau chief to also answer that, I'm sure she's willing to.
And would you mind sharing kind of the intent behind that language?
The intent behind the that result from language is the same as I spoke to, I believe, in my oral summary of rebuttal for avoided methane crediting, that the regulations we're talking about don't specifically have to apply to greenhouse gases, but rather if greenhouse gases are controlled as a co-benefit of other regulations, we would not consider the emission reductions to be additional.
Okay. And so let's talk about actually in the context of greenhouse gas emissions. So does that mean that any greenhouse gas emissions reductions that go beyond mandatory requirements are considered additional?
Go beyond mandatory requirements would be considered additional. I would believe so.
Okay. So if we could just discuss kind of a simple scenario. So if the applicable law requires a 10% reduction and a facility has 2 options to comply, option A, a 10% reduction that satisfies the law, and option B, a 50% reduction that goes beyond. If the facility chooses to implement option B and goes beyond that 10% reduction, does that further 40% reduction count as additional?
I think that might depend on the law, this situation, and the control system. If the only way to feasibly comply with the 10% reduction is to install a control that in fact does affect a 40% reduction, I would not consider that to be additional.
So that was my specific question, but I appreciate the answer. So if a facility had two options, option A, that's 10%, and option B that is 40%, if the facility chose to implement that 50% reduction and gets an additional, would they be able to, would that 40% be additional?
If there was a feasible option to just barely comply, I suppose I would consider it to be additional. I do feel a little bit like we're getting pretty far into hypothetical land in an area of the rule that very much needs to be applied on a case-by-case basis, though.
Okay. Do you think those reductions result from the applicable law in that sense, in that scenario?
Objection, vague for foundation of all of that.
All right, Dr. Razzo, if you can answer the question, go ahead. If you
You
need
know,
it broken down.
I noted in my last answer that I felt like we were getting pretty far into kind of hypotheticals without details. And I do feel like this, when evaluating additionality in particular, it's very much a case by case and situational basis that's kind of difficult to answer these kinds of questions.
And so in the scenario I posed where a facility chooses to go above the requirements to comply and has other options, do those reductions result from the applicable law?
I'm sorry, could you repeat that?
If a facility chooses an option to go beyond the requirements, do those reductions result from the applicable law?
I would think, so generally speaking, I'm going to go back a little bit to grounding this in how we do emissions accounting on kind of an aggregate basis when we're doing things like emissions inventories. Typically, when we're doing real world emission or current emissions inventories, we look at the actual facility emissions. So that, in that case, would account for actual emissions. So this hypothetical facility that has installed a 50% control instead of a 10% control, we would account for that 50%. But when we're looking at the specific effect of regulations, typically what we're doing is going forward in time and we assume people barely comply. So yes, I think the result of a regulation typically is accounted for by barely complying on average. I'm sorry if that didn't quite answer your question. I'm not quite sure how to answer your question.
Do you think the regulations could be clearer with additionality?
I think that additionality is a very difficult thing to write a general rule to cover, and therefore really has to be evaluated, as I said, on a case-by-case basis. We've tried to be as clear as possible.
Okay, thank you. Appreciate that answer. Ms. Borchard, I'd like to move back to you and switch to a different topic. Moving to booking claim, in your rebuttal, which is NMAC Exhibit 124 on page 11, you note that NMED removed liquid transportation fuel from book and claim accounting in its most recent rule red line, correct?
Yes.
Okay. And one of the reasons given for this change is that the air quality co-benefits might not be realized in New Mexico if liquid fuels are allowed to use book and claim, correct?
Yes.
When you discuss air quality co-benefits, you're referring to other pollutants released when a fuel is combusted, correct?
Yes.
Okay. For instance, like criteria pollutants.
Yes.
Okay. But there would still be a net reduction in greenhouse gas emissions for liquid fuels using book and claim, correct?
Yes.
Okay. And NMED is proposing to allow gaseous transportation fuels to utilize book and claim, correct?
Yes.
So under NMED's proposal that would allow gaseous transportation fuels to be eligible for book and claim accounting, would the air quality co-benefits be realized in New Mexico if gaseous transportation fuels were book and claimed?
My understanding is that gaseous transportation fuels do not, the renewable natural gas, the combustion of renewable natural gas does not change the co-benefits regardless of where it's combusted.
How so?
Renewable natural gas is the same as natural gas when it's put into the common carrier. So whether it's consumed somewhere along the way in the common carrier or consumed / combusted in New Mexico, the effects on the air pollution are the same.
Do all gaseous transportation fuels have the same air emissions?
I'm going to have to say that that's a little bit, that's a good question for Dr. Russo is what I'm going to say.
I would say they are the same for renewable natural gas, which is the most common gaseous fuel.
Are there other gaseous transportation fuels that you're aware of?
Yes,
Okay. Can you just name a couple?
hydrogen
Okay.
would be one.
Do those have the same air quality emissions as from natural gas?
You know, I believe so. I'm unaware of hydrogen using book and claim generally. I suppose it would be eligible.
And aren't the emissions from hydrogen water?
Okay. When NMED removed, Ms. Borchard, you agree that do you agree that HB 41, the implementing statute, requires that the rule establish technology neutral mechanisms for generating, obtaining, trading, selling, and retiring credits?
Do you want me to verify that that is the actual phrase of the rule, or should I take your word for it on that?
You can take my word for, and I'm just simply, are you aware of the statutory objective for technology neutrality in HB 41?
Well, I just want to be really careful around technology neutrality because it occurs in the statute twice, and as you just read, the use of that term is embedded in a lot of additional language. So it's, for me, when we're going to talk about technology neutrality, it's really important that I understand which one you're talking about and that the whole phrase be read in as a phrase.
Let's talk about this, the statutory objective in subsection 3.
Okay.
You agree that HB 41 requires that the program rules shall, and then goes to 3, establish technology neutral mechanisms for generating, obtaining, trading, selling, and retiring credits among transportation fuel providers, fuel distributors, and other individuals or entities in the transportation fuel market, correct?
Yes.
Okay. When NMED removed liquid transportation fuels from being able to take advantage of book and claim accounting, did NMED evaluate how that change would comply with that statutory directive for technology neutrality?
Yes.
And how did it consider the statutory objective?
In my evaluation of that and our team's evaluation, it no longer is technology neutral because the impact is not technology neutral.
Okay. Thank you, Ms. Borchard. Dr. Rasso, I'd like to move back to you.
Missing her.
All right. Dr. Rasso, I'd like to begin by addressing the section of your rebuttal testimony titled Incentivizing Emission Reductions in the Oil and Gas Industry and Fossil Fuel Alternative Fuel Pathways. This portion of your testimony responds to Oxy's proposal for a direct air capture to enhanced oil recovery alternative fuel pathway, correct?
That's correct.
Okay. And just so we're all on the same page, NMED's draft rule would require all fossil fuels to use the lookup tables, correct?
NMED's rule specifically requires the fuels that are listed in section 201A, which are fossil fuels, gasoline, diesel, fossil natural gas, fossil LPGs, to use the lookup tables.
Thank you. And NMED is opposed to Oxy's proposal that would create an alternative fuel pathway for, and here I'm just going to abbreviate it, DAC to EOR, correct?
Correct.
Okay.
Sorry, Mr. Tucker, can you ask your question again and slow down? NMED is opposed to Oxy's proposal.
And NMED is opposed to Oxy's proposal that would create an alternative fuel pathway for DAC, that's DAC, to EOR, correct?
Correct.
Okay. On page 13 of your rebuttal testimony, lines 26 to 29, you state that allowing alternative fuel pathways for fossil fuels would create a paperwork game of shuffling crude oil sources with no real or additional emission reductions from the production or use of fossil fuels reported under those pathways, correct?
That sounds correct. I didn't have quite time to find the right page and follow along. But
it's
it
if you look
sounds
on the
correct.
screen.
Oh. Correct.
Okay, thank you. What paperwork were you referring to in your rebuttal testimony?
Mostly the way that I believe you've proposed for this to work does involve putting the produced crude oil into a common carrier pipeline, which would involve liquid book and claim. So I think the paperwork exercise would be demonstrating to the department that crude, well, let me back up a little bit, because NMED's main concern over allowing fossil fuel pathways is that we produce a lot of crude. And I should say this is similar to other states' concerns over this, even though they don't produce as much crude as we do. And we have stringent upstream and midstream oil and gas regulations. It would be, we consume less than 1/10 of the crude that's produced in New Mexico as transportation fuel in New Mexico. So if you allow fossil fuel pathways and liquid book and claim, it would be trivially easy to demonstrate on paper that all of the fossil transportation fuels used in New Mexico are being produced using New Mexico's cleaner methods, and that the emission reductions from those upstream and midstream oil and gas regulations are already complying with New Mexico's CTFP.
And okay, and so in your testimony, going back to your testimony, what do you mean by no real or additional emissions reductions?
I mean, no emission reductions in addition to those already achieved under New Mexico's oil and gas regulations.
Okay. Do you dispute that direct air capture removes CO2 from the atmosphere?
Direct air capture does in fact remove CO2 from the atmosphere.
Okay. When captured CO2 is used for enhanced oil recovery, do you dispute that the carbon intensity of the produced fuel is lower than conventional?
Objection, Madam Hearing Officer. I do not believe that Dr. Rasso's rebuttal testimony specifically talks about what DAC to EOR does or does not do. And so this would be outside the scope of her testimony.
Dr. Rasso, that sounds correct?
I don't believe that is in my written rebuttal testimony.
All right, thank you. And if you would please wrap up your questions for Dr. Rasso.
Can I get a time check, please?
Yeah, you have about a minute left with Dr. Rasso, and you have still almost 10 minutes with Ms. Borchert and 15 with Mr. Ron.
Okay. Okay. Is it your, Dr. Rasso, is it your understanding that Oxy's proposal would allow all conventionally produced fossil fuels to obtain an alternative fuel pathway?
My read of Oxy's red line, as outlined in both my oral summary and my written rebuttal, is that the red line changes proposed by Oxy would allow all petroleum operators to apply for alternative fuel pathways.
Okay, let's talk about that. I'd like to turn to Oxy USA Exhibit 8.
I assume you're going to share it on the screen?
Yep.
I don't have it. Okay.
Okay, turning to page 13. Let's focus on subsection A of section 201. Could a regulated party use a fuel specific carbon intensity unless it was approved by the department under an alternative fuel pathway?
Objection, vague as to under which rule and recommendation the question is based on.
Just rephrase.
Could a regulated party use a fuel specific carbon intensity unless it was approved by the department under an alternative fuel pathway in accordance with 20.2.92.202?
Alternative.
Objection, same question. Is he stating the department's rule or Oxy's rule? I just want the record to be clear.
Okay, just clarify that.
Looking at subsection 3, do you see that? Did Oxy make any changes to the requirement that the department approve the pathway to use a fuel specific carbon intensity?
Sorry, let me review it real quick. I guess I can confirm Oxy did in fact make changes.
That wasn't my question.
Oh.
Did Oxy make any changes to the requirement that the pathway be approved by the department in accordance with 20.2.92.202?
I'm not sure. You have 201 up on the screen. I would have to look at Oxy's red line of 202 to confirm whether or not you made changes to section 202.
All right, so looking right here, so Oxy's changes are in green. Did Oxy make any changes to that part of subsection 3 about the approval process?
I'm sorry, I'm very confused right now. I thought you referenced section 202 and you have section 201 up on the screen.
So section 201 references 202, correct?
I believe so.
Okay, let's go to section 202. Did Oxy make any changes to subsection 202A, the approval process? And Oxy's changes are in green.
I do not see any green.
Okay. If I could just go to 205 real quick, which is the alternative fuel pathways.
Madam Hearing Officer, has time elapsed for Dr. Rasso?
Yeah, you're out of time for Dr. Rasso. You can move to Ms. Borchard or Mr. Vaughn.
And I would like to ask for just a little bit more time. I was directed to Dr. Rasso for the questions regarding project credits. Dr. Rasso's rebuttal testimony did not address project credits. So I did have to use some of my time for Dr. Rasso for that. So if I could just have a few more minutes, I do think that would be appropriate.
Okay, then that's just going to cut into your time with Ms. Borchard.
Great, thank you. All right. Let me, if you give me 1 second just to get to 205. Okay, Oxy proposed to create a pathway under section 205. And if you could, sorry, if you could please turn to follow me on page 24. Subsection 20205 is the tier 2 fuel requirements, correct? Pathways, correct?
A2 of section
A2.
205 lists fuels that shall be tier 2 fuels. And the list begins shall include, as
Okay.
I pointed out.
Oxy's most recent rule proposal does not alter the first section of A2, correct?
No,
Okay.
it does not.
Specifically, the shall include language remains, correct?
Correct.
And NMED's interpretation of shall include means only listed fuels qualify as tier 2 fuels, correct?
No. That is not NMED's interpretation of shall include. If you look at A1, you'll notice that the text there is shall only include.
Mm-hmm.
So that language would mean that only those shall be tier 1 fuels. Shall include would be a non-exhaustive list.
Okay, so the shall include is NMED's interpretation of that is that it's non-exhaustive.
Yes.
Okay, so other fuels could qualify as tier 2.
Yes.
Okay. So going down to 2I, this is line 19. Oxy's proposal is to replace a tier 1 fuel listed in paragraph 1 of subsection A 20.2.92.205 NMAC with any fuel, correct?
The sentence goes on from there, but yes.
Yeah, I'm just asking you about that first part. Correct?
Correct.
Okay. Oxy's proposal would also clarify what may qualify as an innovative method, correct?
Oxy's proposal says innovative methods include but are not limited to.
Okay. Oxy did not propose the term innovative method, correct?
I don't believe you proposed it as a defined term.
That's NMED's original language.
NMED's original language included produced using innovative methods or innovative feedstock that cannot be accurately represented using a tier 1 calculator.
Correct. And this produced using innovative methods language is similar to language in California's program about innovative production methods, correct?
I'm not sure about that. I haven't recently reviewed it. What I can say is this language about listing tier 1 and tier 2 fuels is similar to Washington's language listing tier 1 and tier 2 fuels. I don't believe I've recently reviewed California's language in their similar section.
Okay. Do you agree that Oxy's proposal for alternative fuel pathways is limited to fuels using innovative methods such as DAC or CCS?
I do not.
Okay.
Oh, wait, sorry, could you repeat the question?
Do you agree that Oxy's proposal for alternative fuel pathways is limited to fuels using innovative methods such as DAC or CCS?
I believe so. I'm sorry, I'm going to have to back up and answer this question a little bit more or a little bit more than a yes or no.
Okay.
So your red line here in section 202A2 lists enhanced oil recovery using CO2 from direct air capture and carbon dioxide capture and sequestration. But innovative methods include, but are not limited to, is also included. So I would not say Oxy's language limits innovative methods to DAC EOR.
My question was, is limited to fuels using innovative methods such as?
I would not agree with that because the changes in 201A from shall to may and combined with the shall include in 202A2 would allow fuels other than innovative methods to apply for alternative fuel pathways.
But Oxy didn't propose to get rid of innovative methods, correct?
Oxy did not propose to get rid of language around innovative methods in 202A2.
And Oxy's proposal describes DAC to EOR and CCS as innovative methods, correct?
Correct.
Okay. Do you believe that conventionally produced crude oil would qualify as fossil fuel produced using innovative methods?
There is not a definition of innovative methods, to my knowledge, in any of the red lines, including the department's. In the department's proposal, the innovative methods is specifically tied to tier 1 fuels that can't be accurately represented using the tier 1 calculators. So it doesn't need to be defined. I believe Oxy's red line opens up innovative methods in a way that is not well defined.
How so?
I could not tell you what would or would not be included as an innovative method under Oxy's proposal.
So Mr. Tucker, if you would, you've got about
Okay.
15 minutes and
Okay.
you can divide it between Ms. Borchard and Mr. Vaughn.
Okay, let me. Okay, if my time is up with Dr. Assa, then I have no further questions.
Oh, okay, thank you.
Okay, thank you.
Those were great questions, by the way. Wasn't a commentary on your questions. Let's see. We go to Mr. Harris, and we should take a break in about 15 minutes, Mr. Harris.
Thank you.
Thank you, Madam Hearing Officer. Can you on the board hear me?
Yes.
Thank you. Bureau Chief Borchert, I'm Stan Harris. We've met and talked before. I represent HF Sinclair in this hearing. I am going to ask you some questions about your written rebuttal testimony. If you could turn to pages 3 and 4 of your written rebuttal and tell me when you're there.
I'm there.
On pages 3 and 4 of your written rebuttals, you state that combining the 2026 and 2027 compliance periods into one 7-quarter period allows, quote, regulated parties almost 2 years from April 1st, 2026 to April 1st, 2028 to become familiar with the CTFP reporting and tracking software before they demonstrate compliance, end quote. Is that correct?
Yes.
Does the department anticipate that there could be potential software bugs or other unforeseen issues that will occur while parties are simultaneously trying to familiarize themselves with the reporting and tracking software?
I'm going to, I think the question, Dr. Rosso is in charge of the developing of the DMS and is more familiar with it. But I don't think, I want to just say at the high level that, well, yeah, do you want to answer that?
Sure.
Okay.
Perhaps you could repeat the question.
You bet. And hello, Dr. Rasso. Good to see
Good
you
morning.
again. Does the department anticipate that there could be potential software bugs or other unforeseen issues that will occur while parties are simultaneously trying to familiarize themselves with the reporting and tracking software?
I think unforeseen issues are, of course, unforeseen. Perhaps with deploying new software, there are always bugs I'd be happy to stipulate, or there's always unforeseen issues.
Thank you. Does the department have a plan to address those potential issues?
Generally speaking, yes, we have a plan to address those issues. We have our IT contractors. I guess I should say it depends on what the issues are. Unforeseen issues are unforeseen, so we can't necessarily have a plan for every single thing that could happen. We are prepared for software glitches or unforeseen software issues. We have our IT contractors under contract for that type of issue through 2027 or 2028, whatever the state purchasing office allowed us to put them under contract through. There's a 4-year limit on contracts, and I anticipate that we would recontract them to continue to address issues after that.
Thank you. This question will be to Bureau Chief Borchert, but whichever person is the correct person to answer, I might appreciate it. Again, on page 3 and 4 of your written rebuttal, Bureau Chief, you state that combining the 2026 and 2027 compliance periods into one 7-quarter period allows, quote, 20 months for the credit market to develop and equilibrate, end quote. Is that correct?
Yes, I see that.
Will liquidity in the program develop if deficits are generating at the same time that the credit market is developing?
Could you ask that again? I'm not quite,
Sure.
I want to make sure I'm following.
Sure. Will liquidity in the program develop if deficits are generating at the same time that the credit market is developing?
I think I'm not quite sure what you mean by liquidity. Can you further explain that? Maybe
Do you
rephrase
think
it?
that the program, well, let me put it this way. Do you think that the program will succeed if deficits are generating at the same time that the credit market is developing?
Yes.
And why do you think that?
It's been demonstrated in the other programs that have done this similar startup, the parallel startup of both having deficits and credits generated in the same quarters and in the same compliance period.
Which program specifically are you referring to?
Washington.
Thank you.
And I believe Canada as well, although you'd have to check me on that.
Does the department's proposed rebuttal rule address the possibility of an initial credit shortage in the market?
Could you describe initial?
You have April. You are discussing April 1st, 2026 to April 1st, 2028.
So initial, you mean the first compliance period? Do
correct?
we, so could you rephrase restate the question and make sure I understand what you mean by initial in that context?
Sure. If initial is in that context, the question is, does the NMED's proposed rebuttal rule address the possibility of an initial credit shortage in the market?
Yes.
How?
Well, during that time period, there would be two fuel forecast reports. And so the way that the rule addresses a potential shortage would be as exposed in the fuel forecast reports.
On page 3 and 4 of your written rebuttal, Bureau Chief, you state that NMED's new rebuttal rule allows credit generating parties until March, excuse me, I'm going to restate it. On page 3 and 4 of your rebuttal, you state that NMED's new rebuttal rule allows, quote, credit generating parties until March 30th, 2027 to report credits for the first compliance period, end quote. Is that correct?
That's what I said there. I think that could probably use a little bit of clarifying.
What clarifying are you talking about?
Well, credit, just like deficit generating parties, credit generating parties have to report the credits that they are seeking based on fuel delivered in the quarter after which they deliver that clean fuel.
As written, or perhaps as you've just clarified, does this mean that under the rebuttal rule, deficit generators will have only one calendar year to get an accurate idea of what the market looks like?
We'll have only one. No, they will have the 7 quarters.
The effective date of the program is April 1st, 2026.
Right.
And your statement says that the rule allows generating parties until March 30th, 2027 to report credits for the first compliance period. Is that 1 year?
Oh gosh. Okay. Credit generate until March and to report credits for the first compliance period. Oh, I think it's a typo. That should be 28.
And what typo are you discussing?
I'm saying that the date should be just like deficit generating parties, credit generating parties have until March 30th, 2028 to report all the credits. Well,
So that is a typo in your rebuttal testimony?
that's right.
Is that also a typo in the rebuttal rule?
No.
Does the department anticipate that there could be potential software bugs or other unforeseen issues? Oh, I apologize. I just already asked that question. On page 3-4 to 4 of your rebuttal, written rebuttal, you state that the new rebuttal rule allows the department, quote, additional time, end quote, to do several things, including the following: assuring the DMS is functioning as anticipated, to train program staff, to answer questions from the deficit and credit generating parties, and to develop outreach material. Is that correct?
Yes.
Do those listed items contribute to a functioning program for its participants?
I think so. Yes.
Should the department have a functioning program for participants before they are subject to a rule?
I don't think they're mutually exclusive. No. I mean, I think there's no time frame. I mean, are you saying that you think this should all happen before the board adopts the rule? I'm not quite sure. I know what you mean.
My question is simply, should the department have a functioning program for participants before they are subject to a rule?
Yes, and I think that everything we're doing demonstrates that that will be the case.
And would that be because it would only be fair for the department to subject regulated parties to a program that is fully functioning?
Maybe we need to make sure we're on the same page as to what you mean by fully functioning.
Do you believe that the program as proposed in the rebuttal rule will be fully functioning by the first compliance period, the end of the first compliance period?
Yes.
Why do you believe that?
The rebuttal rule and the program that it sets up, as we can all tell by looking at the 70 plus pages of it, is like a machine, right, with many different parts. And whether we're talking about the software system that people register through, or the market that it sets up, or the safeguards in place, or the feasibility on the kinds of fuels that we can demonstrate will participate in the market, the reliance on programs like this in other jurisdictions, the team, this amazing team that we have assembled to help implement it, and the future additional staff we'll get, that's all part of it, right? I mean, I think that I can't think of anything we've forgotten to get this program up and running, and to make sure that the first compliant that we have everything in place to get the compliance period done. That is, I think, all of our jobs, but probably most importantly, my job is to think of all the pieces. So if you're asking me if I have thought of all the pieces we need to get this program up and going to the best of my ability, yes.
On page 7 of your written rebuttal, you discuss and rely on the credit market as experienced in Washington's program. Is that correct?
I wouldn't say I rely on it. I use it as additional evidence.
Did you just rely on Washington's program as support for your position in this oral testimony?
Objection, Madam Hearing Officer. The credit market and reliance, there was a whole panel yesterday. So I stated my objection. I realize that it's probably not appropriate for this particular question. But if this line of questioning continues, just know that's my objection.
Okay, I thought it was a fair question. Go ahead, Ms. Borcher.
Could you please repeat it?
Sure. On page 7 of your written rebuttal, you discuss and rely on the credit market as experienced in Washington's program, correct?
In my written rebuttal, yes, I have brought forward this graph from the Department of Ecology of Washington, demonstrating what has happened in their first, I think it's 10 quarters of their program.
And you also, I believe, just testified that you believe the Washington program supported your testimony regarding liquidity of this program developing. Is that correct?
Well, it's one of the factors that supports my understanding and and the evidence that we have. I mean, I think it's super important to remember that the modeling that was done BCA and in the Zephyr scenarios are really the very much more robust reliance that we should have about why we think the credit market will work in New Mexico.
Okay, and you go on to state on page 7 that concerned parties, including HF Sinclair, quote, have not presented credible evidence on why New Mexico's credit market will behave differently than the program in Washington, end quote. Is that correct?
Yes, with an emphasis on evidence.
I'm sorry, with an emphasis on evidence, what does that mean exactly?
Oh, sorry. The concerned parties have not presented credible evidence. That is important to my statement, is that I don't believe that HF Sinclair and other parties have presented credible evidence on why our program, why New Mexico's program will not work.
Have you read Michael Carr's own rebuttal testimony in this matter?
Yes, it's been, it's been days and I've read a lot, but yes, I did read it at the time when it was submitted.
Were you present for Mr. Carr's oral rebuttal testimony in this matter?
Yes, I was.
Do you understand that specific evidence has now in fact been presented of the challenges with implementation of the Washington CFP that should be considered as risks for the New Mexico CTFP?
I think this kind of goes back to whether it's an opinion or if it's presented by credible evidence. So I understand that was Mr. Carr's opinion. I don't believe I saw any actual evidence of what he was asserting in his testimony.
Mr. Harris, would you wrap up with Ms. Borchert, please, and then we'll take a break.
I will, thank you. I just want to make sure that I understand. You do not believe that there is any credible evidence that Mr. Carr presented regarding the Washington program. Is that your testimony?
Objection asked and answered.
It's overruled. Go ahead, Ms. Borchert.
Could you restate the question, please?
Sure. Are you testifying now that having reviewed Mr. Carr's rebuttal testimony, having heard Mr. Carr's rebuttal testimony here in person, that you do not believe that Mr. Carr's testimony constitutes credible evidence regarding the Washington program?
Objection, Madam Hearing Officer. This requests Sir rebuttal on the stand for Ms. Borchert. The questions directed at rebuttal testimony that she heard or read. Asking if she heard or read it is fine, but she can't provide opinions on that. That was not within the scope of her rebuttal testimony.
Your Honor, the statement is the concerned parties have not presented credible evidence on why New Mexico's credit market will behave differently than the program in Washington.
No, I understand, and I understand the distinction you're making between rebuttal and Sir rebuttal. I still think it's a fair question. Ms. Borchert, if you can answer it, go ahead.
Yeah, I just want to say that, it's kind of what I mentioned in my oral statement. We are all scientists or economists here on our team. We draw our conclusions based on information that is presented, that is technical and scientific, and can actually, we can actually look at the data and see if the data presented makes us change our mind, right? And so I just want to be clear that that's what I'm talking about here, is that it has been no saying that the market behaved this way, or saying that it didn't behave this way, or saying it was having this problem or having this other problem is not what I would consider credible evidence.
There's just a couple more questions along this line.
All right.
And then I can wrap up.
Yes, please.
So would you require for evidence to be credible, specific discussion of, for example, reduction targets in the Washington program? Excuse me, reduction targets in the Washington program?
I don't actually know what you mean.
It's possible she hasn't formed an opinion about that. And if that's true, you can just say that, Ms. Borchert.
Oh, yeah, I mean, I think you'd have to point me to actual information that I could speak to.
Thank you. That's all I have. And so that, Madam Hearing Officer, so that you know, I don't have any further questions. So that's it.
Oh, okay, great. So let's take 15 minutes. We will come back at 10:55. And Mr. Weatherby, at that point, I will call on you. Let's come back from the break, please. Righty, Ms. Sona, I see you at the podium.
Madam Hearing Officer, I just wanted to clarify the order of the remaining cross-examination. My understanding of it was that we would be going to Mr. Maxwell, then Mr. Weatherby, then CCAE, and then our biofuel folks and renewable diesel folks, Growth Energy, Rio Valley Biofuels, RNG Coalition, and concluding with Infinium and Mr. Noy's clients. Is
Okay,
that
so I'm following the same, I'm sorry, handwritten list of folks, just going from bottom up rather than top to bottom. I have Mr. Weatherby next, then Mr. Maxwell, then Ms. Tremblay, who I don't think is with us, Ms. Veracruz, Mr. Sorayas, Mr. Lobdell, Mr. DeSalen, Mr. Smith, Mr. Duff, Mr. Nasco, and Mr. Noyes. I've been following kind of the same order from the other direction for the whole hearing.
okay? That helps me and helps these folks. Thank you.
Okay. Mr. Weatherby, do you have questions of the department panel?
Yes, I do, Madam Hearing Officer. Can you hear me?
Yes, thank you. Go ahead.
Okay. All right. Thank you very much. Good morning, panelists from NMED. Most of my questions are going to be for Mr. Vaughn. There may be a little spillover to the other participants on the panel, but they mostly go towards the openness or transparency of the process. And I'll try to get them through them quickly. But first, let me thank you, all three of you, for your work on behalf of the people in New Mexico. Mr. Vaughn, could you go to your written rebuttal, Exhibit 119? And I wanted to have you read into the record a couple of things, but if you could find that first, and I'll give you a minute to pull it up.
Good morning, Mr. Weatherby. I have it open.
Okay. For the record, does the document that's listed and labeled on the rebuttal as rebuttal exhibits 119 through 123 represent your official rebuttal with attachments in the matter before us right now, known as EIB 25-23R?
Objection, Madam Hearing Officer. That question asks for something that's already been admitted under oath. Mr. Vaughn is sworn in. And if I may move to the podium, I have a broader concern to raise for your consideration.
All right. Hold on.
Madam
Mr.
Hearing Officer,
Hold on.
I haven't even asked. Okay.
Ms. Sona.
Thank you, Madam Hearing Officer. I'd like to raise a concern in a motion, oral motion for your consideration. Cross-examination is reserved for parties acting in good faith to test technical or factual assertions, not to generate material for outside publications or advocacy campaigns. Here, Mr. Weatherby, who has entered as a party in this rulemaking proceeding, has repeatedly held himself out to be a journalist and has published written commentary about this rulemaking and about department staff who are testifying here today. This has occurred while this rulemaking has been ongoing. Specific for that, and to reference what I'm discussing, I'll move for introduction into the record, and I only have one copy, I apologize. The specific purportedly news blog that Mr. Weatherby has published on his website, The Candle, that is directly related to his line of questioning. On the record, Mr. Weatherby's ongoing commentary about department witnesses and positions demonstrates that his participation is not directed toward assisting the board in developing a fair and complete technical record, but rather using this forum as a platform for advocacy and to conduct fact-finding outside the regulatory process for his own gain. Should the hearing officer consider the party Mr. Weatherby a journalist, his conduct is also inconsistent with how journalists gather information. Journalism ethics require neutrality, transparency of purpose, and respect for the subject's ability to decline comment. Journalistic practice does not empower a self-identified reporter to enter as a party in a formal rulemaking proceeding to question individuals under oath in a structured setting where those individuals cannot decline to respond without risk of adverse interference or procedural consequence to their oath. Allowing Mr. Weatherby to ask questions for his online articles under the guise of cross-examination risks turning this hearing and future hearings before this board into some kind of backdoor press conference rather than a regulatory evidence-based proceeding. To be clear, the department is not seeking to inhibit or silence the press. The press is free to observe, report, and comment as is appropriate in a transparent public process. The department participates in this kind of inquiry almost daily with its staff, whom Mr. Weatherby has been in contact with through both the public office and the IPRA office. The department's request here is far narrower. We're asking the hearing officer to protect these witnesses from compelled examination by an individual purporting to act in a journalistic capacity, where in any other professional context, these witnesses would have the right to decline to comment. Thus, the department respectfully requests that Mr. Weatherby not be permitted to conduct cross-examination of the department witnesses. If the hearing officer determines that he may have some form of limited participation, we request that any questioning be confined strictly to factual clarification on matters and documents in the record, that no character, motive, or credibility-based questioning be allowed, and the witnesses be allowed to truthfully answer no comment. Thank you.
All right, Mr. Weatherby, I would encourage you to focus on gaining a better understanding of the witnesses' testimony. Do you have some comment that you'd like to offer in response to Ms. Sona's objection?
Well, yes, I do. I find it strange that she's allowed to, first of all, disparage me in this context when I have not done anything of that nature towards anyone. I've actually asked questions, actually a few weeks ago. There's nothing in the rule that describes or puts conditions upon someone who can be a party. Whether I'm a reporter or someone just interested in the matter, the rule is clear. If you want to change the rule, then you got to go through a process. If the department doesn't like having the ability of, and she can characterize me as a blogger, I really don't care. Under the First Amendment, anyone has a right to proceed in this fashion. There are all types of people who are journalists who do different types of reporting. We've been reporting on New Mexico. I have been, and the Candle has been doing so since 2012. We've done a lot of reporting. Some of it's investigative reporting. We were very curious about this particular bill matter because of the legislation that had been filed, and because we feel the process needs to be open. This is a learning experience for me. So if I have offended anybody or transgressed any rule, I'd like it to be pointed out to me specifically. I don't know what she introduced, what Ms. Sona introduced as a document. I'd like to see it, but I don't have it. I'm not sure which she's referring to. I did have questions. I took a lot of time putting questions together for the participants here who about their testimony, about what's in the rebuttal testimony regarding the interactions that I felt needed to be more open and weren't, but that they refer to. My questions are pertinent to their testimony. And I don't think any public employee deserves to be specially recused from any type of questioning by the public, whether it's me or somebody else, if it's relative to the jobs that they do. It may be uncomfortable for people, but this, as we can all see from what's been going on in Washington for the last several years, that there's a breakdown in the public's confidence in the way their government responds to them. So that's, I guess I'm eating into my time, which I think is incredibly unfair. I would also point out that
So, Mr. Weatherby, I will restart your time. I don't count these kind of discussions against your time.
okay, thank you.
Here's the thing. I'm just going to be listening carefully to your questions. I'm actually trying to listen carefully to everybody's questions in terms of whether they are relevant to the testimony that was given by the employee. And to the extent that the panelists say, well, that was not part of my testimony, we're going to have to respect that. If they don't have an opinion on something, then we're going to respect that. But I would, I agree with you that the rulemaking process in New Mexico, like so many of our administrative hearing processes, is wide open for better and worse. And I would like you to proceed with your questions. I don't know what Ms. Sona is going to offer either. Let me invite you, Ms. Sona, to share it with everybody, maybe in an email, and we'll take up that question sometime later. I don't want to take the time today to take up that question. So I understand, Mr. Weatherby, you said most of your questions will be directed to Mr. Vaughn. Let's start over.
Okay, thank you very much, Madam Hearing Officer. And Mr. Vaughn, thank you for your service to the people in New Mexico. If you look at Exhibit 119, and the reason I'm asking if this is your testimony that's included on the website is because as a document is not to question the veracity of your statement. It's just to make sure that it coincides, because you didn't, as I remember, read it verbatim. You provided a summary of it. So that's why I'm asking if that rebuttal exhibits 119 through 123 is your official testimony.
119 is absolutely my rebuttal testimony. I do not remember the last exhibit number. I do believe my last exhibit in this rebuttal process, though, I believe it's 123. So I believe that's correct.
Okay. And I do note that you made a correction in your, I think there were two documents that were inverted, 120 and 121. And you'll see in my question, I think I've made the right connection there. So if we can proceed, would you go to page 1 of your rebuttal testimony? And I do want this so that there's no accusation that I'm taking things out of context. Could you please go to page 1 of your rebuttal testimony and read paragraph 2?
Sure. My rebuttal testimony provides the Environmental Improvement Board with 1, facts about the discussion sessions held between the second week and third week of the rulemaking hearing to seek resolution on contested issues, and 2, counter arguments for some of the issues raised by other parties to the rulemaking and public commenters.
Okay. Could you go to what you in that sentence? I apologize because I pulled up the wrong person's testimony when I was trying to follow you. So and I'm quoting where you stated the discussion sessions held between the second week and the third week of the rulemaking hearing to seek resolution on contested matters. Were you referring to the sessions that were held on October 30th and 31st?
Yes, that's correct.
Okay, thank you. Would you please go to the same page 1 of your rebuttal testimony and read the third sentence in the third paragraph, which begins with the word specifically?
I will. I feel that it's imperative to read the preceding sentence as well.
That's
So I'll read
fine.
both.
That's fine with me as well. Go right ahead.
Almost no party has meaningfully contested the facts in NMAD Exhibit 34, which I note as my original direct testimony in this matter. Then it goes on to say specifically, no party contested that 1, NMAD met its legal notice requirements, 2, NMAD went above and beyond those requirements, and 3, the department is leading the development of a proposed rule that is built on the feedback from public and interested parties, science, and the provisions of the enabling statute that provided the framework for NMAD's regulatory proposal.
Thank you. Now, could you go to page 3? And there's a footnote at the bottom of page 3, footnote number 4. Could you read that as well into the record?
I will read it, and I will also, when I read it, make the correction that I've already noted elsewhere.
Correct. That's fine.
Footnote 4 says, all the hearing parties that wished to participate as discussion parties either actively or passively accepted the participation guidelines and confidentiality considerations listed in NMAD Exhibit 121 that were established by NMAD in advance of the discussion sessions, except 1. Therefore, because Bruce Weatherby did not accept those participation guidelines and confidentiality considerations, Mr. Weatherby was precluded from participating in the discussion sessions.
Thank you. Could you provide for us your understanding of what the confidentiality conditions you referred to in that footnote are or were at that time?
Yes, one moment. So these confidentiality considerations can be found in NMAD Exhibit 121. This is an email chain describing and essentially eliciting parties' participation in the discussion sessions. It is from my counsel, and the confidentiality considerations. Would you like me to read those aloud, Mr. Weatherby, or have I pointed them out clearly enough?
Well, you've pointed what is in there. I was looking for your understanding of what you considered to be those. Are you stating that what is written there is what your understanding of them is to be?
That's correct.
Okay. Okay, and understanding that you referred to 121 and not 120 as it relates to this. In your rebuttal testimony, will you explain how you became aware that Bruce Weatherby was precluded from participating in the discussion sessions?
Objection, Madam Hearing Officer.
I think
Reach.
what?
He's asking for likely privileged information.
How he became aware?
That's not a privilege. I'm not asking what was discussed. I'm just asking how he became aware that I was precluded from participating in the sessions.
I think that's a fair question. I guess just to caution Mr. Vaughn, if I'm wrong about this and lack an understanding that it does in fact involve privileged information, just say that, please.
Madam Hearing Officer, even the existence of a conversation with counsel, requesting him to confirm or deny through how he became aware after he just testified, this information all came from counsel. That is privileged and impermissible to require him to testify to under oath.
Okay, I'll accept
Particularly
that,
from
Madam.
relating to the prejudice and dangers of my motion.
All right, thank you. Thank you, Mr. Weatherby. Do you have other questions?
I do. I have several questions, and I do want to actually speak to what Ms. Sona just brought up. I believe she said that the answer was that he learned this from counsel. Is that correct?
Madam Hearing Officer, counsel does not testify.
Right.
I'm asking him if he heard it from counsel.
And that was what she was objecting to and saying was subject to privilege. Do you have other questions of Mr.
Well, I would ask the question then, Madam Hearing Officer, in the email chain that Mr. Vaughn provided that's attached to this, it's clearly, I don't know what the privilege that's being violated here is. It's included in the email. He's on the email, she's on the email, counsel's on the email. I'm asking to confirm if that's where he heard it. I guess I'll rephrase the question. Did you hear of it from anyone else other than counsel?
I think the short and simple answer is honestly, I don't actually recall. But what I do recall is that the first time that I became aware of this situation was your response to the email, Mr. Weatherby, which included a CC to myself, and I believe was a direct email to my counsel. That was the first time I became aware of the situation at large.
And you've just helped us all along because you've acknowledged something that I was going to try to establish through some questions. So you did, I copied you on that email. Is that correct?
I believe you did.
And is there any reason you didn't include in your rebuttal testimony, you included a string of emails regarding the conditions, including ones that were sent to me, eliciting my involvement, but you didn't include the email that I sent, nor Ms. Sona's response, did you?
I mean, on its face, to answer that question, yes, that is correct. However, I regularly check in with the smart comment portal. I became aware that you had submitted that email chain through that process. I believe I also saw a motion that I believe you filed, also including that email chain. And I've also been extraordinarily transparent with footnote number 4, the list of participants. I've explained exactly the condition that you were not that you did not participate because you would not accept those considerations. So I
Okay.
believe I've been transparent about that in this process.
I was curious as to why you hadn't included it. Did you, do you recall, I'm going to read to you Ms. Sona's response, okay, because it does pertain to the topics that you brought up and my exclusion from that process during
Madam
those
Hearing Officer,
discussions.
I would object to both the relevance of this testimony, lines of questioning, the helpfulness to the board regarding this line of questioning, as well as reading into the record something that's not evidence that's been submitted in this.
I will be happy to submit the emails in question, Madam Hearing Officer, as evidence. I can do that via email to Ms. Jones. I have no problem with that. I'm trying to not take up as much time as, take up as little time as possible.
I understand. Is there a question on the other side
Yes,
of?
there is a question.
Okay, go ahead.
And you know what? I really find, with all due respect, I realize I'm not an attorney. This is not an area that I deal with each day. But I am accustomed to asking questions and many times not getting answers. By the way, Ms. Sona was suggesting that I communicate with the agency she's been contracted to help in this matter. Yes, I do. They don't respond at all to other than an IPA request. I have questions relative to the openness and to the assertion by the people on the panel who basically feel that they have been open and that this process, if you read their testimony, has been an open one that invites participation. And I was specifically excluded from the process. And yes, I am a reporter, and I would become potentially a vehicle of the public getting more information about this process. So I don't see, if they're claiming to be wanting to be open and they are open, that I can't ask questions that relate to maybe limits that they put on their openness.
Okay, so thank you, Mr. Weatherby, for that. Your time is ticking by, even adding a few minutes for our discussions. And I feel like these first 10 or 12 minutes, you have been doing a good job of sticking with Mr. Vaughn's specific testimony. So please go ahead.
Okay, and I will try to be very quick. I only have a few more questions, and I don't need to ask the other panelists. I could, if I run out of time, and ask them, there was some testimony in their part, but I think I can wrap this up. So am I allowed to read this, hearing officer?
Yes, go ahead.
Okay. So Ms. Sona responded to me, stating, writing, while NMAD has no obligation to include every party in informal settlement style discussions, you, meaning me, Weatherby, were invited as a courtesy to support collaboration contingent upon agreement with the established confidentiality and participation guidelines. NMED intends to preserve that integrity, the integrity of that process, and to ensure that no participant feels constrained by concerns that statements made in good faith could later be used in advocacy or litigation, or in the media. Since you will not agree to the confidentiality considerations, NMED must respectfully decline your participation in these sessions. And it goes on. So, Mr. Vaughn, do you remember reading that?
I think I read it once, probably.
Okay. So did you share Ms. Sona's intention or desire to ensure that no participant feels constrained by concerns that the statements in good faith could later be used in advocacy or litigation or in the media?
Objection, Madam Hearing Officer. Mr. Weatherby has admitted that his purpose for this line of questioning is to elicit information for his own investigation. That's an inappropriate question to ask this witness, and I ask that he be allowed to state no comment to a reporter.
All right, so.
Ms., this is a question anybody has a right to ask, Madam Hearing Officer. He testified. I'll wait until you hear what you say. I'm sorry.
Hold on, Mr. Weatherby. So, Ms. Sona, as I understand it, Mr. Weatherby is asking Mr. Vaughn about the integrity, if you will, as you saw it, the integrity of the process, integrity and confidentiality of the process in between the direct case and the rebuttal case. Mr. Vaughn, in my mind, you've heard Ms. Sona. Mr. Weatherby now has read Ms. Sona's words into the record. Do you have anything else to offer about the confidentiality or integrity of that process that was conducted between the second and third weeks of the hearing?
The only thing I really have to add is that I think most of the parties that did participate in the discussion sessions found those confidentiality considerations important. And I think as you know, we've gone through the parties that participated in this rebuttal process, and I should give credit to the parties here that they have respected those confidentiality considerations as well. And I intend to do the same on our end. So I really don't have anything to add beyond that.
Thank you very much, Mr. Vaughn. Mr. Weatherby, if you have a final question of Mr. Vaughn, again, even extending your time.
Thank you.
Yeah.
Mr. Vaughn, do you feel that there is any tension or conflict between the interests of individual parties, protection of confidentiality, and the public's right to understand what is going on in the process, the public process?
Objection, Madam Hearing Officer. The premise of the question presumes let me back up. For the same objections that I've been offering previously, this is an inappropriate question, not designed to illuminate this board. It's becoming apparent it's intended to illuminate investigatory purposes and draw out information that and opinions that are not within Mr. Vaughn's factual description of these proceedings.
All right. So Mr. Weatherby, I'm going to rephrase the question perhaps just a little bit. Again, in the event Mr. Vaughn has anything to add to what he has said, and he may or may not, I think what Mr. Weatherby is asking is, to the extent you have described and what you characterized as an open and transparent process with a lot of public engagement that went above and beyond what you might have been required to do, even in a rulemaking in New Mexico. Does the fact that there was a part of that process that was not fully public without agreeing to a confidentiality provision, does that compromise or undermine your characterization of it as an open and public process?
I think that's a really rather complicated and nuanced question. I think the way that that it's been phrased by Mr. Weatherby and by yourself, Madam Hearing Officer, I just frankly don't have an opinion unless we were to break that down into several multifaceted questions that I could answer individually. But on its face, no, I don't have an opinion.
I was trying to be helpful. I'm sorry if that wasn't helpful.
Madam Hearing Officer, if I may.
Yes.
First of all, I want to make it very clear, and I have, despite me getting off to a rocky start a few weeks ago in my questions for Mr. Vaughn, I have a lot of respect for the folks who are doing their job. Personally, I think this rule is headed in the right direction. I'm concerned about this process because of a number of reasons. I would also point out that levied as a reason, offered as a reason, is that Ms. Soner inferred or stated that they were following the rules of evidence. I'd point out that the meeting that they had was at NMED's request and put together. It's
Madam
an
Hearing Officer.
extension. Madam Hearing Officer, I would like to just finish and I will end.
All right,
I think
go ahead.
in addition to the meeting being sponsored and held by NMED, it was purported to be at the request of EIB or under the board's guidance or suggestion that it happened. And there's this kind of quasi-real or not public hearing connotation, in my opinion. And in light of that, as I understand the rules for the conduct of hearings for the EIB, is that the rules of civil procedure and the rules of evidence shall not apply according to 20.1.1.400A, which is part of the process that we're undergoing. And this seemed to be a sidestep of that process. And so when Ms. Soner introduced the rules of evidence as the reason that they could do this, I find it to be an incredible stretch. So with that, I'll end my questions and thank you all very much.
Thank you, Mr. Weatherby. Yes, Ms.
Madam
Soner.
Hearing Officer, I would move to strike from the record all of the statements being explanatory by Mr. Weatherby. That was testimony. That was not responsive. That was not responsive to the motions. That was direct testimony in connection with a public comment that he filed that he then read into the record. If that information is not stricken from the record, or an order from you that the board cannot consider that information, then I respectfully request to cross-examine Mr. Weatherby on the testimony that he just provided, as well as the public comment that he submitted.
All right, thank you, Ms. Soner, for your objection. It's noted. I don't disagree with everything you just said, but I don't think, frankly, cross-examination would be helpful at this point. Let's move to Mr. Maxwell. Mr. Maxwell, do you have questions of the department panel? Mr. Maxwell? Oh, now I can, yes.
I had to fix a setting. No questions.
Thank you very much. Do we have Ms. Tremblay? Do we have Ms. Vercruz? She said no questions. Mr. Sorayas, do you have questions of this panel? Mr. Lobdell, do you have questions of this panel? Mr. DeSalen, will you have questions of this panel?
Yes, Madam Hearing Officer, Ms. Gerson is going to be doing this cross-examination. Thank you.
All right, so Ms. Gerson, if you would please choose one of the three department witnesses, conduct your examination of one of them, and then we'll take a lunch break.
Okay, thank you for that direction. And before I begin, this is Sarah Gerson for the record on behalf of Coalition for Clean Affordable Energy. And I want to note that I think it was really helpful for stakeholders and the board for the department to have an opportunity to clarify on the record their intent with regard to some of the proposed provisions in the rebuttal version of the rule in response to rebuttal from CCAE. And so I want to thank the department for their creativity in suggesting an avenue for getting those clarifications on the record. Thank Dr. Rosso for taking the time to prepare that statement, and thank the hearing officer for the flexibility to entertain that solution. And with that, I would like to begin with some questions for Dr. Rosso. Dr. Rosso, my questions are about the application of the newly proposed provisions related to avoided methane credits to methane from livestock manure. And I am hoping to ask you about provisions that you quote on page 9 of your rebuttal testimony. So if you could go there and let me know when you have that language handy, I would appreciate it.
I'm turning there now. Give me one moment.
Of course, take your time.
I'm in that section of my testimony. My version, unfortunately, does not have page numbers, so I might need to flip further.
Oh, sure. It was, I was looking at the bait stamps on the bottom right. Oh,
thank
yeah.
you.
Okay.
Sorry, I am at bait stamp 9.
Okay, thank you. Okay, so starting at line 21, you quote a newly proposed provision that the amount of avoided methane is based on previous methane emissions that occurred at the facility or feedstock production location in the 5 years preceding transportation fuel production. Did I get that right?
That's correct.
And this is part of how the department would assess baseline conditions for emissions at a facility, right?
That's correct.
And when it comes to identifying the amount of methane from that facility in prior years, does the department intend to rely on independent data like satellite data or self-reported data from the industry?
I am sorry, I had a microphone issue. I imagine that this data would be required as part of the alternative fuel pathway application, so it would be data reported by the applicant.
And are you aware of any sources of independent data regarding emissions from factory farms that you could use to double check industry's self-reported emissions data?
I think there's several sources of data. I haven't examined them specifically for data from large agricultural operations. I know that the U.S. Department of Agriculture maintains the AgStar database, though that may not include emissions data. The National Emissions Inventory also does include emissions from agricultural operations and livestock operations, but I don't believe they break it down onto a per facility basis.
And are you aware if the data in any of those government databases is based on industry self-reported data or as opposed to independent data collections like flyovers or satellite data collection that does not require cooperation of the industrial emitter?
Oh, I believe specifically for the two I just referenced, it would be a combination of reported data from industry and applying emission factors to things like head counts.
Okay, thank you. Different questions about the same provision So it contemplates a 5-year look back for setting the baseline, right?
Correct.
And the specific language is about 5 years, quote, preceding transportation fuel production, right?
Correct.
Are you aware that several factory farms that currently supply methane as a transportation fuel, in the 5 years before they had used that methane for transportation purposes, they had been putting that methane to productive use, burning it for electricity generation on site. Is that a general practice you're aware of in industry?
I'm aware that renewable natural gas is used for other purposes besides transportation.
Is it the intent of this provision to only include methane in the baseline as a historic source of methane emissions if it has not been put to productive use in things such as electricity generation on site?
You pose an interesting question I haven't previously fully considered. As I'm thinking about it on the spot, I would think that if the methane for the previous 5 years, or the biogas, I guess, that has not yet been refined, has been collected for useful purposes, I would not necessarily consider that to be additional.
Okay, thank you for that clarification. I have questions about one other provision that you quote on this page of your testimony. And that's the one that starts on line 8. It says, transportation fuel feedstock that would otherwise result in methane emissions to the atmosphere is a byproduct of another process or industry. And that's an eligibility requirement for methane to be able to count towards avoided methane credits, right?
Correct. That is part of the list that the applicant must demonstrate for the avoided emissions to be eligible.
And when you use the term byproduct in this context, that is it your intent to distinguish that from co-product methane, which would not be eligible for avoided emissions credits?
I think that is the intent. And perhaps for the benefit of everyone who doesn't spend so much time thinking about life cycle analysis and exact definitions of main product, co-product, byproduct, the distinction here is what are the main, what are the drivers of why you are doing something? A byproduct is typically something that's waste or that is not the main point of the activity the industry is doing. So we're talking here in the context of the dairy industry. The main product in that case would be milk, and a byproduct would be animal waste, because it is a waste of that industry.
Thank you for saving me a couple more follow-up questions, but I do have some more questions. Would you agree that it is best practice in the field of greenhouse gas life cycle accounting to treat byproducts different from co-products?
Generally, yes.
And would you agree that one of the criteria for determining whether something is a byproduct or a co-product is whether a significant portion of a facility's revenue is from producing that thing?
That is one way in which those terms are defined. As I note in my written testimony, though, I believe I include a definition of byproduct from the U.S. Department of Energy Information Administration in my excuse me, in my testimony. The department has not carefully considered how we are going to define byproducts. Currently, I think that will have to come in further guidance.
Yes, thank you. And you do also note in your testimony that you intend to release further guidance on this topic. And is it your intent to provide further guidance for how this need to distinguish byproducts from co-products would play out in a situation where a facility raises cows whose manure is about half as valuable as their milk?
I think that would be a consideration in defining byproduct versus co-product. I'm not prepared to commit or to comment on specific ratios.
Okay, thank you. I appreciate all of those clarifications, and I have no further questions for Dr. Rosso. I have no questions for Mr. Vaughn unless Dr. Borchert refers questions to him. But I would take the direction to break now for lunch and just let you know that I will have a few questions for Ms. Borchert after lunch.
Oh, okay. Well, if you'd like to ask those questions now, you finished with Dr. Rosso a few minutes early. Can you pursue your questions now?
If you'd like, sure.
Please do.
Dr. Borchert, you were Ms. Borchert, you were so close to lunch. I have questions for you related to a discussion at page 12 of your rebuttal testimony, in case you'd like to go there. I think it would be good to have that handy in case you need to refer to the language. So please let me know when you're there.
I'm there. Thank you.
Thank you. And so you'll see there's the last full paragraph before section 5. In the second sentence of that paragraph, you state that NMED has included book and claim for gaseous fuel to remain in the program because it exists in other states. Did I get that right?
Yes.
Now, was it your goal to well, let me rephrase that. To the extent you saw it to prioritize consistency with other states, can you let me know why you think that consistency with other state programs is important or helpful?
I heard all of your question except for the very last phrase. So could you please repeat it?
In your opinion, why is consistency with other state programs important or helpful?
Did you say or helpful? Okay.
I can.
That's a big question. Why is it important or helpful? Well, to begin with, we are resting on the shoulders of, or we're standing on the shoulders of giants, right? Low carbon fuel programs have been around for, I guess, well, almost 2 decades. Were first developed in California, adopted by other jurisdictions. And so it's really important that we remember their overall intent, which is it's a greenhouse gas emission reducing program. So it's important, I think, as we develop our New Mexico program to remember the foundation of why these programs exist in the first place. It's also helpful to have our programs align as much as possible because we have in the development of this rule and will, I suspect, as we implement the rule, rely on the experience and the advice of other regulators and how they've handled particular situations to help guide both the guidance documents that we will be periodically releasing, as well as case by case decision making. So and that being said, New Mexico is unique in our geography, in our population, in our fuel mix, in our vehicle population, in the goals we're trying to achieve, in our emissions, our greenhouse gas emissions profile. So that too has to be considered as we figure out how to adopt a program to New Mexico.
Would you say that one of the benefits of having rules that are consistent with what has been successful in other states is that you avoid the risk of unintended consequences if you see a track record of how a similar regulatory structure has played out elsewhere?
I'm sorry, there certain words keep dropping. So could you just say it again? Because I missed a key word in your question.
Oh, I'm sorry. Let me hunch over my computer a little more. I wanted to ask if you think one of the benefits of adopting rules that are consistent with those in other state programs is that you reduce the risk of unintended or unanticipated consequences because you have the benefit of being able to look at the track record historically of how those rules have played out in other states.
Yes, I think absolutely that's true.
And in the rebuttal version of the proposed rule, isn't it correct that the department plans to allow booking claim accounting to be used as a process energy in biofuel refining and synthetic fuel production?
Yes.
And just for clarity, when I say process energy, do you understand that that includes the methane that refineries burn to produce that heat that they need to make biofuels?
Yes.
And do you think it's fair to say that refineries use a significant amount of process energy?
Now, I just want to make sure we're talking about biofuel refineries.
Yes.
Yes. Yes. I can't speak. I imagine yes. I don't have any direct knowledge of that.
Okay. Are you aware that Washington and California only allow book and claim for process fuels under very limited circumstances?
Little less familiar with that. I do yes, a little less familiar.
Has the department estimated how many credits parties could generate by taking the unique approach to book and claim for process energy that you've proposed? And the magnitude of credits that could be generated by using biomethane for process energy to produce biofuels like renewable diesel?
Objection, Madam Hearing Officer. This question's outside the scope of Ms. Borchardt's testimony. We had a whole panel yesterday dedicated to what the department has looked at for credit generation.
So Ms. Gerson, what part of Ms. Borchardt's testimony would this relate to?
Well, Ms. Borchert is the witness who is defending the department's proposed approach to the availability of book and claim for gaseous fuels. And I am trying to probe what considerations she made in determining that this proposed approach would be appropriate.
All right. So Ms. Borchard, if that can relate to your testimony, go ahead.
Yes, that is a question really for our modeling team, and I feel like they are the ones that need to answer that.
Okay, so let me ask a different question focused on your role. When Ms. Borchard, am I correct that you are responsible for the decision to propose allowing book and claim accounting for gaseous fuels used for process energy?
Objection, intimidating the witness.
Do what with the witness?
Intimidating the witness.
Oh, Ms. Borchard, if you find it intimidating, but if you can answer the question, go ahead.
I want to refer to my opening oral rebuttal statement, which talked about the robust process that we as a team used to decide all the factors that are in the rule. So I would not want to claim the sole proprietary person, or I don't know if I'm saying that right. I am not the person who decided this would be on the rules. This was a collective team decision.
And is the person who is most knowledgeable about the decision to allow book and claim accounting for process energy on this panel?
She just said it was a team decision, Ms. Gerson, not one person.
Okay. Well, I guess to the best of your knowledge, in this team effort that you participated in, can you tell me if, or I guess maybe I'll focus it on your role as you were participating in this team process. Did you have any analysis that you were able to rely on how book and claim accounting for process energy could affect the credit market?
We certainly discussed it. And I think it was too much of a hypothetical situation for us to necessarily felt like we could understand what the impacts were. I mean, I say that with caution though, because I think that again, my modeling team might have a better answer for that. Yeah.
Oh, I don't mean to cut you off.
No, that's all I said. I was done. Thank you.
You have about
Okay, thank
2
you.
minutes, Ms. Gerson.
Okay, thank you, Madam Hearing Officer. I just have a few more questions. Would you agree that in general, if there is a significant amount of unexpected credit generation from the use of biomethane as a process fuel, that that would have the effect of driving down the credit price.
Objection, Madam Hearing Officer. Calls for speculation, as well as I think we've established that the impact with credits and this topic, that's outside the scope of Ms. Borchardt's knowledge and testimony.
All right, so Ms. Borchard, if you would just confirm whether it's outside the scope of your testimony and whether you can answer without speculating.
Yeah, I don't feel comfortable answering that question. It is outside the scope of my testimony.
Okay. And would you agree that as a matter of general market dynamics in a clean fuel credit market, that when the credit price goes down, that reduces the incentive to use clean fuels in New Mexico?
I don't think I do agree with that.
Oh, can you explain why not?
Yeah, because some clean fuel use happens regardless of what the credit market is doing. And it also feels a little generalized because, there's what matters in the credit market in part is not just the credit price, but actually the delta between the standard and the clean fuel, right? And so even if the clean fuel, even if the credit price is low, the more of a delta you can get between the standard and the clean fuel you are producing, it still might also incentivize the continued use of clean fuels. It's a too generalized statement. It has to be broken down by actual individual fuel.
Okay. Thank you, Ms. Borchert. That was my final question. And thank you to the whole panel.
Thank you very much, Ms. Gerson. Let's return at 1. Back from the lunch break, please. Unruly witnesses. So we are back after a lunch break, and we've come to what I believe is our final oral public comment period. If you would like to contribute public comment, non-technical public comment to the record, you can certainly do that. We've chosen Monday as the deadline for that. That's Monday, November 24th. If you'd like to make oral comment, though, this is the session for that. I will ask you to spell your first and last name. I will ask you, pursuant to the board rules, whether you swear or affirm to tell the truth, and I will ask you to keep your comments to about 3 minutes. I understand Ruth Striegel is on the platform. Ms. Striegel?
Yes, thank you.
Hello. Oh, you're coming through loud and clear. Would you spell your first and last name, please?
My name is Ruth, R-U-T-H, Striegel, S-T-R-I-E-G-E-L.
Thank you. Do you swear or affirm to tell the truth?
I do.
Thank you. Go ahead.
Thank you for the opportunity to comment. My name is Ruth Striegel, and I live in Albuquerque. My concern about the future of our planet has led me to my current role as the board chair for New Mexico Interfaith Power and Light, where we acknowledge that the active care of the natural world is central to spiritual life and social justice, that we are interconnected with that natural world, and that our health and survival is totally dependent on its health and survival. I'm grateful to Governor Lujan Grisham for her leadership in this arena, to the Environment Department for the work they've done to develop this rule, and to your board for your careful consideration of the proposed rule. Reducing transportation pollution is critical to our future, especially in light of federal attempts to roll back regulation of greenhouse gas emissions. I urge you to reject any loopholes that allow industry to circumvent the intent of the rulemaking, such as giving bonus credits for methane from factory farms. There should not be credits for any form of methane. Further, don't support crop-based fuels, which are often characterized as clean, but actually often lead to deforestation and degradation of agricultural lands. I ask you to fully support the benefits of electric vehicles, especially when the electricity that powers them comes from wind or solar. Reject industry attempts to undermine our transition to clean energy and clean vehicles. This board has an opportunity to pass a rule with very real benefits by cutting emissions, promoting healthy air, and supporting jobs in our state. I'm sure you are familiar with the golden rule, do unto others as you would have them do unto you. This mandate is a part of all religions, asking us to treat each other with respect, love, and empathy. With that in mind, I ask you to pass the strongest rule possible to keep our communities healthy and resilient. Your leadership matters. Thank you.
Thank you very much, Ms. Striegel. Is there anyone else on the platform who would like to offer public comment in? Terrific. Ms. Cedillo Lopez? Can you unmute yourself?
There. Okay. Thank you.
There you are. Would you spell
Thank
your
you.
first and last names, please?
My name is Antoinette Cedillo Lopez, Antoinette, Cedillo, Sedillo, Lopez, Lopez.
Thank you. Do you swear or affirm to tell the truth?
Yes, I do.
Thank you. Go ahead.
I want to thank the Environmental Improvement Board for considering the proposed rule. I think it's, I've really been so hopeful and proud of the work that has been by the board during the administration, during this governor's administration. And I think that I want to really convey that New Mexico has an opportunity to lead here. Other states may look to follow what we do. And the other thing that has been really disappointing is the federal government's attempts to roll back the regulation of greenhouse gas emissions. Here, the board has an opportunity to pass a program that can cut emissions, support jobs here at home, and promote healthy air. I think it's win-win-win. And that's why the board must really adopt a strong, effective rule and that keeps all of these benefits in New Mexico. One of the other important things is energy efficiency vehicles. They cost less to fuel, and by promoting efficiency, the rule can help New Mexicans save money while we also cut pollution. The proposed rule appropriately recognizes that some technologies are more efficient than others through the inclusion of energy economy ratios, or EERs. I just really urge the board to ensure that the EERs remain part of the final rule. Other states, policymakers, and industry are looking to us for leadership, as I said, and so everyone is looking at you. And I just really want to strongly encourage you to do the right thing with these rules and to compliment you on so many of the other rules you have passed that have been good for New Mexico's environment. Thank you very much.
Thank you, Senator. Is there anyone else on the platform who would like to offer oral comment at this time? Say it again. Okay, thank you. I don't see anyone in the room I don't recognize, so I think we will go back to our technical case. When we broke, Let's see, the next person to ask questions would be Mr. Smith. Mr. Smith, do you have questions of the department panel? He's not on. Is Mr. Duff on the platform? Okay. Is Mr. Nasco on the platform? He is not. Mr. Noyes, we have you in the room.
Graham Noyes for Verde Clean Fuels. And just very brief questioning here. Wanted to direct my questions to the Bureau Chief, Ms. Bouchard. Ms. Bouchard, we've all been through a lot of testimony and cross through this proceeding, and there's been a lot of discussion of many different issues, including the issue of how the team that put together this rulemaking made decisions. Is it accurate to say that you carefully reviewed the program structures in Washington, Oregon, and Washington?
Yes.
And is it also accurate to say that to the extent possible, you followed those program structures if you thought they were a good fit as a team for New Mexico under its special circumstances?
Yes, and also as keeping the enabling statute in mind as well.
And yes, thank you for referencing the statute also. So within those parameters, when you made decisions for making different rules for New Mexico, what were the types of things that would cause you to make those different decisions?
Well, I'm trying to, I think it's hard to generalize.
Well, maybe I should ask a more specific question then.
Okay.
Specific to sustainable aviation fuel, alternative jet fuel, the team made the decision to work to have a fixed benchmark standard. What was the reasoning for that?
The reason for that is that the statute does make very clear that that all of the clean fuels that are brought to the state get a CI determination, a carbon intensity determination, based on their actual greenhouse gas emissions profile. And then that gets compared against the standard. And so, and the standard in the case of conventional jet fuel is, is what the standard against which alternative jet fuels would be compared is the gallon of conventional jet fuel they replace. That logic leads to a flat line.
In another specific situation, actually, there were several situations where the proposal provides additional flexibility for book and claim. What would you say were the driving reasons for that additional flexibility?
The recognition again that that the statute wanted us to treat all fuels equally, and in some of the other states, my understanding is they do allow process energy, for example, for. Are you talking about process energy book and claim? I'm sorry, I'm starting to get a headache.
Oh, that's certainly appreciate that. No, I was asking specifically about some book and claim provisions, such as going to using biomethane as a process energy in facilities.
Okay, yeah. So So it seems like that we interpreted the statute's technology neutral approach to what gets counted for greenhouse gas emissions um, of a fuel produced to mean all of it, right? I think some states have electricity as an allowable part of the process energy, renewable energy, as well as gosh, I'm forgetting the other example. Anyway, so it felt like to be true to the statute, we needed to make it inclusive.
And a third example here pertains to the definition of synthetic fuel and avoided methane emissions. And I would characterize it as subject to stringent additionality requirements. You established the ability for synthetic fuels to participate in the marketplace, including e-fuels. And also potentially methane if it made those standards. Again, what was the reasoning for that innovation in this program?
Okay, so I think with regard to the avoided emissions question, that we are not trying to treat avoided emissions in this program differently than in other states. And I guess I would have to say I'm not quite familiar whether other states wouldn't allow synthetic fuels. I mean, where we are also agreeing with other states is that we do not think that, or the rule does not allow for an alternative fuel pathway for a fossil-derived fuel.
And did New Mexico's status as the number 2 oil and gas state with 25 to 30% of the general revenue coming from the oil and gas industry also influence your thinking as you design this program structure?
Not the latter part of your comment, which is where the money comes from, or your question, but recognizing what an important industry oil and gas is in our state, and recognizing that we would be the first state that has such a significant production of oil and gas certainly factored into our thinking. I'm not sure if I can think of an exact way in which it factored into it, but it's always front of mind. It's impossible not for that to be front of mind.
And after this week of rebuttal testimony and cross-examination, do you still have confidence in the decisions that you and your team made regarding this final version of the regulations that was presented with your filings?
I do.
And what is your reason for that?
Well, my reason is that, first of all, I have a stellar team. And I think that we really complement each other, and that we each might go down different rabbit holes and take different positions in seeing some aspect of, a decision before us, or an ask or an element before us, and come at it in different ways. And so by the time we all get to the same place, it's because we have batted the idea around enough. And I also just think that, we also just have experts in various, areas. And so, Angela's an air emissions expert, Micah being an economist, and Colt very intent on what is a transparent and open process. Anyway, so they just mean that as a team, we've just been very solid in the development of the rule. And also, I mean, when I think about some of the questions that were asked today on the stand by the attorneys, it reminds me of the fact of where I was 18 months ago when we started trying to understand what this rule was about, right? We've had, between the 4 years of trying to get it passed in the legislature and the 18 plus months of actually digging down and trying to understand it, and all the conversations that have happened, it just means that the product 113, NMAC Exhibit 113, the rebuttal rule, has just been gone through the ringer so many times that I do feel confident in it.
Thank you, Ms. Bouchard, very much for your testimony and for you and all of your team's hard work throughout this process. I've certainly appreciated the opportunity to participate. Thank you, Madam Hearing Officer.
It's been a pleasure having you in New Mexico, Mr. Noyes. Let's see, Ms. Sona, do you have redirect?
Thank you, Madam Hearing Officer. Very brief. Mr. Vaughn, you've spent maybe a collective 4 days up at this witness table, maybe even more. This second round, you guys have answered many questions. What is the most important aspect or aspects of your rebuttal testimony that you shared that you want to leave the board with consideration of?
Thank you. I think I want to touch on two subjects. The first being my testimony on deferral. And I just want to highlight that the authority to defer section, as I think has been demonstrated throughout this hearing, it's critically important to everyone. It's something that I personally was attracted to as we began the development of this rule. And I think it's not unreasonable to look at the reasons why. It is a complex program. And when you're first sort of introduced to it, I think it can be scary. And I think when fear enters the mind, the first thing people want to do is look for a way out. And I get that. I understand that. I think that's what the deferral section is there for. And so I'm just highlighting that because we've spent a lot of time, and I've spent a lot of time really thinking deeply about what deferral means. And so given that there are two methods of deferral, I do want to just maybe briefly circle back to some questions that Namoga was asking me yesterday. I do think there are criteria, to be clear. In section 601B1 lists the criteria for an emergency. C3 lists the criteria for a forecast. In those two categories, emergency deferral is for things like natural disasters, equipment failure, things that cannot be foreseen and reasonably prevented. And that requires a little bit more discretion than, say, the forecast deferral, which I think we've stated does have less discretion in it. And the forecast deferral is about making sure that there's a regular cadence to look for problems in the market. And that criterion that I discussed yesterday really does not leave much discretion to the department at all in issuing a forecast deferral. I just highlight this because, again, I think this is important to a lot of people. It's important to our team. And I just want to reassure the board that we have really tried to think hard about what it means if our modeling somehow comes out in a wash and we need to use it. The protections are there to ensure that that happens. The second topic I wanted to touch on was the discussion session, and especially some of the questions I got this morning. In that process, NMED's role, really much of what the department said at the discussion session is actually in the public record. I just want to make that clear. For example, our discussion rule that we brought to that session, that is one of my exhibits. It's in the record. The changes that we made to the rule in that process and the justifications for those changes are in my testimony. And really, I don't think anyone has challenged that characterization. So what the point here is, I think sort of ironically, very little of the department's confidentiality considerations actually applied to the department itself. I think most of the confidentiality considerations enabled the other parties to have discussions amongst themselves in an open, in a manner that was allowed for open dialogue. And I think that's really the importance of those confidentiality considerations. And just as a second point, you know, we didn't just hold meetings to hold meetings, right? I think if you look at that discussion rule, you'll see that we have proactively shifted our positions before going into that discussion session. And we tried to shift our position based on the evidence that we heard in the first 2 weeks of the hearing. I mean, of course, that wasn't easy. This has been a challenging process for sure. It's required a lot of deep thinking, and it's required balancing a lot of competing and often mutually exclusive interests. And you know, I think that's something that this board often does. But I just wanted to highlight that the discussion sessions are really focused on trying to reach compromise that would foster a healthy market and avoid cutting the legs out from under this program. So in many respects, I think NMED has already split the baby, if you will. And so my ask to you is that you keep the rule intact. Thank you very much.
Thank you very much, Mr. Vaughn. Dr. Rasso, similarly, you've been sitting up here with Mr. Vaughn. Your technical expertise and the depth of your knowledge has been extensively tested. For your rebuttal testimony, what perspectives do you want this board to come away with as an understanding of what the most important considerations are for their deliberations on this rule?
Wow, it's a big question when you ask it like that. And I already knew you were going to ask it too. I think one of the things I want to make clear to you, the board, is today we spent a lot of time, or I spent a lot of time talking with the council from Oxy about whether or not their red line changes effectively would limit fossil fuel alternative pathways to only innovatively produced crude. Not that it doesn't matter, words of course matter. Even if Oxy had effectively limited it to innovatively produced crude, the department would still oppose allowing those fuels to have alternative fuel pathways. No other state has opened that door to allowing the conventional transportation fuels to have alternative fuel pathways. And we've gone as far as any other state has ever gone to allowing the petroleum industry to get credits in a clean fuels program. California allows project credits. Oregon and Washington have not done. Washington is allowed to do project credits per their statute, but they haven't opened that door yet because it's a complex problem to do any crediting in the petroleum industry. We've gone possibly even further than California. California has very defined sets of things that the petroleum industry can get project credits for. Our rules are very broad in what could be allowed as a project credit. And really, the correct way to reward, so to speak, industry partners that go above and beyond regulation to reduce emissions is through that project crediting.
Thank you, Dr. Rasso. Bureau Chief Borchert. You and your team were charged with bringing this across the finish line. With all of your testimony that you have provided about the proposed rule you're asking this board to adopt, specifically here in the rebuttal phase, what are the important aspects you want to leave this board with?
Chair Sweeney, I'm sorry, members of the board, hearing officer Orth. I think what's really important, which you've heard from us multiple times, is that Part 92 or the rebuttal rule acts as a whole, right? And we've provided substantial evidence on why all those pieces of the whole fit together as a whole, and they function as a whole. I mean, the analogy I could think about was like, what if you take an internal combustion engine, for example, and you decide, oh, well, the battery, maybe not. Or you take out the fan belt, or you take out the alternator, you take out the gas tank, and you still want your car to take you places, right? Well, it seems ridiculous in my example that car would get you to where you want to go, right? And it even seems like you might not want to take an alternator from a Nissan and stick it in, you know, in your Ford, right? That the clean fuel program, by and large, is a very complex system. And we have spent a lot of time developing that system. So I would, and we've provided evidence on why that system works or how we expect it to work. So we've stress tested in essence. I would say that the idea of removing EERs, the idea of changing the timeline when the whole point of a clean fuel standard is to reduce greenhouse gas emissions. The idea of not allowing a parameterized NM are all parts of that system, that machine. And I think the possibility of changing some of those, which you might be tempted to do based on the testimony you've heard, really could jeopardize the program as a whole, could jeopardize it here in New Mexico, and could also have unintended consequences as we think about us within a framework of 5 other programs that have already adopted a clean fuel program. So for example, when Dr. Rosser talks about us going further with the project credits and the ability for the innovative petroleum industry companies that we have in our state to participate, right? That's already kind of making a lot of other people nervous, you know? And it would just be scary to have us be the ones that unravel other people's programs. I would hate that. So some of these changes might cripple or actually destroy our program unintentionally. So I would very much caution you to think about how to like be able to tinker with it. And I also think that our substantial evidence really supports the rule as it is. And I would be worried about by changing something that then our technical evidence no longer supports the program as approved, and then makes it subject potentially to an appeal, that we are, you know, that we're trying to be very careful to make sure that everything we say and everything we do has the technical substantial evidence to support it. So I think my bottom line to you guys is, first of all, as you've heard so often, we're incredibly grateful that you guys are here. We know how much time this has taken. We know how much time it takes to be a volunteer member of the board. So thank you for being here. And we do all encourage you to please adopt the rule as is presented in Exhibit 113. Thank you.
Thank you, Madam Hearing Officer. I now happily turn this panel over to board questions.
Thank you very much, Ms. Sona. Member Garcia, would you like to start?
Thank you, Madam Hearing Officer, and thank you to the panel. I just have a couple of questions, broad questions, and then one final comment. There's been a number of parties that have brought up the concern that changes on the federal level regarding EV credits, et cetera, may negatively impact New Mexico in terms of, may have an impact on this rule in terms of suggesting that perhaps in your modeling and your projections, you have overestimated the amount of credits that may be available. And I know you have a good relationship with the other states that have a low carbon fuel program, particularly Washington, I gather. Have you spoken with them? Well, I'm assuming you have spoken with them about the impacts of the federal changes. Have you heard them say they plan to make any changes or updates or amendments to any of their programs based on the federal changes?
So I think that's a really good question. And I think we were one of the few states, or maybe Washington, that actually the changes were happening in real time while we were developing the rule, right? So the one, a couple things that we have in our rule, but the one in particular is the availability for OEMs, auto manufacturers, to get credits in the rule, right? We explicitly put that in there as an additional incentive in case the incentive or the requirement they do under the new motor vehicle emission standards goes away. So we felt like that was an important piece, and that was very well received by all the manufacturers we talked to. So that's, and in fact, even public comments recommending that that we do that. And anyway, so and also I think the questions come up earlier about how much do people actually drive their cars? Well, the good thing is when OEMs submit to get credits in the program, we're going to know exactly how many miles those electric vehicles are driving. So it's still just a data point. Everything Dr. Ross has said about the averages still is true, but it'll actually give us insight into vehicle use that we don't have a way to get any other way. And I think that there are a lot of other states who are curious about us having put this provision in, who are curious about how this will go. And this program also piggybacks on the reporting requirements in NMVES. The reporting requirements in the new motor vehicle emission standards are not impacted by the waiver that California is granted under Section 177 that allows us to adopt those programs. So there are still provisions in New Mexico's program that will continue to feed this program, even if they're adopted under a different program. So, and then of course we're all, okay, I'm rambling now. You got me started. I actually have something to add. Okay, but one more thing first. The Climate Change Bureau's performance measure is EV adoption, right? Every quarter we check to see how we're doing at registering EVs. So apart from this program, apart from Section 1, the NMVES, we are actively trying to figure out how to increase EV adoption, whether it's light duty, medium duty, or heavy duty. So it's also important to think that this policy is not the only game in town, right? Even just driving demand by increasing understanding, by, there's a zillion different outreach things we can do to help people decide that an EV is for them. So that is also really important for this program. And I think I'm going to let Angela speak, and I'm also going to say that I went off on the EV tangent. So if there were other parts of your question that were not EV related, you're going to have to repeat them.
Oh, I was just going to add, because your question was about other states, and following the congressional actions that we've heard a little bit about, California released. I can't remember the exact wording of what they called it, but it was a roadmap to transportation decarbonization document talking about their plan moving forward. And front and center in that plan was continuing and strengthening their low carbon fuel standard. So, as we face federal actions challenging, really even state climate action and rolling back the actual federal regulations, this type of policy becomes very important for transportation decarbonization.
Thank you. I appreciate those answers. And then also, regarding how this impacts the regulated community, I can understand when any new rule comes out, there's concerns about how it's going to be implemented, and they don't know exactly. Businesses need certainty. That's what they're looking for. And I understand that. And I'm hearing concerns from the regulated community from the testimony that with the rollout of this rule, there could be some glitches and problems and various things unforeseen. And that it may cause them to be out of compliance and sometimes through no fault of their own. So would you be, if that, if something like that comes up, and this is short of triggering a deferral, let's say, if something comes up through no fault of theirs, how would you, would you be compelled to go and issue an NOV and penalties? What would be your thinking process going through a scenario like that?
That's a great question. We haven't really highlighted some of the aspects of the rule. There's what's in the rule, and then there's also, I think, to what you're also speaking to, which is how does it actually work on the ground. I think that if there's problems with people, let's see, registering and reporting their fuels, that seems like an easy, and our understanding from Washington is this happens all the time, right? They basically have one person whose full-time job it is to work with parties to make sure they understand what buttons to push in the right order to report their fuel, right? And so there's the reporting piece. Once they report, the credits or deficits are automatically generated. Then if you're a deficit generating party, it's your responsibility to go out and figure out where can I buy a credit to offset my deficit, right? And so I think we too have a role to play there. We'll have a sense of who has credits. I mean, anybody can see that in the system, but maybe we have contact information, a monthly or quarterly compiled information about the credit market prices. We're going to have a backstop aggregator, right, that will have credits that we can put them in touch with to actually buy credits for them. There's the trigger that if at the end of the compliance period, somebody's out of compliance, that's when we can trigger the credit clearance market. The whole purpose of the credit clearance market is, again, to bring those two parties together, the people with credits and the people with who need those credits to offset their deficits. There's a provision in the rule that allows 5% carryover of deficits into the next compliance period. So, after doing all these things to help people try to get compliance, there's a little bit of a cushion. And then I guess if none of those work, then we might be in the compliance and enforcement piece. And of course, the first part of the enforcement is to investigate what's going on. Why are you having these problems? And, to have conversations about what can we do to help you not have these issues. I mean, hopefully it doesn't take that long, but that is the first phase of compliance before it accelerates depending on what is found. There's some conditions like fraud, that we're less likely to be lenient on, but other things, will be very much, especially because we're all going to be new at it. Every enforcement case, should we get to that, will be new to us. So we're going to have to, learn and talk to our counterparts and other programs. What do they do? And make a path forward that's going to ultimately result in the success of the program. The success of the program is when everyone's in compliance.
Great, thank you.
I think you covered it.
I would like to just add one brief statement. Thank you for the question, Member Garcia.
Yes.
I think one thing that may have just been lost in this hearing is that, of course, we did all of the outreach and engagement we did for this rulemaking, but it's also important to note that really the secondary purpose of that was to help us, the staff, build relationships with the regulated community. And I think we've done that in a very significant way. We've had the opportunity to interact with people who deal in the fuel market industry on a day-to-day basis. We had those members on our advisory committee. As I've documented in my testimony, we've had so many conversations with so many people and built a lot of relationships. So just building on what Ms. Borchard is saying, I think having built those relationships in this rulemaking process will make that a little bit easier when we go into the implementation phase.
Thank you. I appreciate that. And just one comment I'd like to make is I appreciate that you all have, taken the time in the interim to work with the parties, the regulated community, the conservation community, and make additional changes to the rule. And I know that you all have worked very, very hard in putting all this together and trying to accommodate all the different needs. It's almost a whack-a-mole situation. You take care of one and somebody else says, wait, that's not going to work for us. So it's been a colossal amount of work and a balancing act. And I understand that and I appreciate that. It's been a lot of work for all the parties to get their head around this rule, including us. So I just want to say I appreciate your accommodating and building relationships, as you say, that goes a long way. So thank you for all your work.
You, Member Ely?
Hi, good afternoon. I also want to express my gratitude for working with the parties to try and find more alignment in the rule. It actually makes our job easier if we don't have to focus on areas where there is agreement. I also appreciate your responsiveness to the 6 points I presented and other points that the board made at the end of the direct testimony. I feel like each of those issues I brought up was addressed and well addressed, and I appreciate that very much. So I have a couple broad questions and a couple more pointed questions. We started down the path of sustainable air fuels with the cross from Mr. Noyes there. And I just wondering if you have a sense about what that flat benchmark will do related to added credits or meeting emissions targets, or is the amount of jet fuel used in the state not great, so it may not have an impact on either of those? I'm not looking for specifics, just in general terms.
I think in general terms, it will incentivize the use of alternative jet fuel in the state. I think you're also, as also was brought, became clear by a lot of the other testimony, SAF, sustainable airline jet, SAF, alternative jet fuel, aviation fuel, alternative aviation fuel also requires a lot of infrastructure, right? So it will take time for alternative jet fuel to be able to be used in the state. And it's also true, I think, that we don't use that much. And it is, yes, you notice it is flat. In a lot of other states, it joins the diesel curve and then declines at that, which means that over time, once those intersect, and I did look at that, I think it's in 2029 actually, or 2031. I'm sorry, don't hold me to that. At one point they intersect. And after that, then the reason that that curve follows the diesel curve in so many other states is because they didn't want the fuel providers to have to make a choice strictly on credit generation choice on whether to make alternative jet fuel or renewable diesel. And so our program does actually incentivize, all things being equal, you get more credit for producing alternative jet fuel than you would renewable diesel. However, as I said, there's so many other factors that go into the decision making on whether somebody actually chooses to turn that into alternative jet fuel. The largest, I think, being the infrastructure capacity and the off-takers, right? We don't actually know whether any of the airlines that fuel and fly out of the Sunport want to use alternative jet fuel. Because even with an incentive like a clean fuel program can provide, it still usually comes at a greater cost of fuel compared to conventional jet fuel. Anyway, so at the highest level, that's what I got for you.
Thank you. Yeah,
Okay.
that's good. Then let's see, on avoided emissions. So why the time frames in there that, especially related to feedstock, it's limited to 20 years, a 20-year use?
So, on avoided emissions and the 20-year time frame, I believe Mr. Wade from the RNG Coalition introduced this earlier. California, until very recently, had a 30-year time frame on avoided emissions, and they have recently changed their time frame to 20 years. Washington, just in their latest rulemaking, which their newest version of their rule was published in between our first 2 weeks of hearing and this final rule, they've just now adopted kind of these similar kinds of guardrails on avoided emissions, and they've also adopted a 20-year time frame. My main reasoning for writing that 20-year time frame in here was to match what other states have done and rely on their analyses to back that up. I believe the original 20-year time frame is about the payback period. For how long does it take to essentially pay back the amount of capital costs to install this type of digester.
And could that particular farm with this feedstock come back to the agency and request another 20 years?
Not under the rules as written.
We have 20 years to look at it.
Yeah.
I asked a different panel in about the capacity use for FSE.
Yes, I believe you did. About other states?
Yeah, and I didn't get in,
Yeah.
they didn't know. And I'm wondering, can you tell me, do the other jurisdictions that have clean fuel standards base their FSE on capacity?
Yes. So I believe in California, they're explicitly called capacity credits. So California and Washington actively have an equivalent of our fuel supply equipment credits. Both of those states do limit them to zero emission vehicle infrastructure, so hydrogen and electricity infrastructure. Oregon explicitly does not have this mechanism.
At all, or just based on capacity?
Well, Oregon does allow fueling credits, of course, for hydrogen and electricity. They do not have capacity-based crediting in the same way that the fuel supply equipment credits are capacity-based. Instead, they have a mechanism that's called advanced credits, where essentially someone who's building fuel supply equipment can essentially take a loan against future credits.
Let's see, I have another question. Yeah. And it goes to the enforcement provisions. And it's on page 91 of Exhibit 113. And so this is probably directed at you, Ms. Borchert. Under Section C, 2E, it says you will assess reasonable costs not accounted for in the annual CTFP budget for the department's expense of investigating and pursuing a violation or non-compliance. Could you explain how the agency will do that? How will the agency recoup the costs of an enforcement action?
I'm sorry, I was not able to find exactly the section you're talking about. Could you maybe
It's
give
on
me the
page
line?
91 of 113.
Okay.
Of Exhibit 113.
I'm there.
Yeah, and so you go to C under compliance order.
Okay.
Yep. And then Section 2, line number E on line 31.
Okay. I see. I think that those are the kinds of procedures we will develop. I guess are you asking like how we know what the costs are beyond what is in the budget, or by how would we decide what's reasonable? I'm not quite sure what part of that question you're asking specifically.
So how will you assess the reasonable costs that you don't account for in your budget?
Okay.
And how will you recoup that from the person, the company that you have issued the compliance order to?
Yeah, I feel like, I mean, we'll know what's in the annual budget and about how much time people will be spending on compliance per se. So I think that the assessing the reasonable cost goes for any additional work, what might not be considered routine for compliance. But actually, what the details on that would really need to be worked out in a guidance document or an SOP that we would develop the time, before we need it, hopefully.
Okay, that's all. Thank
And
you.
I also just want to add, this is something that the department is working on across the board too. So we'll have to make sure it's, not only in line with this rule, but also the processes that NMED follows in general.
Yeah, this has come up in other draft rules, and that's why I'm asking too. It's not the first time we've seen language like that. Thank you.
Thank you, Madam Chair.
Good afternoon. And I just also want to thank everybody for these these 3 weeks of intensive work, as well as the previous months and years that the team, as you shared with us, has been working on this rule. As well as the board, having to delve through thousands of paper and testimony. And so as we come to a close here in this portion of the process, I just wanted to kind of share, we're trying to juggle schedules, and one part of your testimony, your written testimony, in terms of when the rule would be effective and that timing, I understand was adjusted as part of some of the incorporation of comments from the initial testimony. So I think right now we're actually looking to adjust our schedules just because of availability of board members and trying to juggle that with the holiday season. So that's the premise to my follow-up question, where you had mentioned, Ms. Borchardt, about the timing with the April 1st effective date as being achievable if we made a positive decision on a rule by December 8th. So I know. So it's looking like we might have to push that back. Is that going to affect, and if so, we'd love to hear what kind of milestones we need to try to meet to have deliberation if we have to kind of push that back, just because, as we shared, we're a volunteer board and we're trying to make juggle a whole bunch of people's schedules through this. And I know this might be a big can of worms I'm opening, but I think it's a pertinent question that I would love to hear.
Yeah, it's a very pertinent question, and I think that this maybe would best be actually done in collaboration with council. I mean, I can tell you that, I think you probably know all these things too, right? It has to be at state rules for 30 days.
Right.
It has to be published in the New Mexico Register. So I have to look at when so that means at least getting to the new, I don't think it has to be published in the New Mexico Register and have a certain timeline. So let's say April 1st, that would make it March 1st. We also feel like it's very fair for a rule this size to give state records adequate time to actually look at it. They do, we've shared it with them, but they check to make sure formatting wise, it fits state record rules, right? So some time for state records. Then there's the time from when you make your deliberation to actually get the transmittal signed and the final rule and was the concise statement along with it to state records. That takes a little bit of time. So without actually doing the math, back calculate, those are the kinds of things that when we were always thinking about when could we have an effective date, recognizing that those steps that I've outlined, and then that doesn't even, that includes the kinds of processes that you've been working out with your hearing officer, which is the final statement of reasons, the final rule, your time to deliberate. Those are also pieces that ultimately feed the whole process. I don't think I can add anything else to that. I mean, I would say that, so those are the milestones. I would say that, boy, February 1, trying to get it approved by February 1 would still allow us. I don't know, but yeah, Kelsey, if you want to is it Kelsey allowed to answer that question?
So let me just offer this much. The board had chosen tomorrow to deliberate on Hayes and December 8th to deliberate on this one, even though that is way shorter than usual because we believed we were not going to have critical mass of board members starting December 9th. Now it appears that we may have had a brief reprieve such that they might be able to move deliberation on Hayes to December 8th and deliberation on this hearing to sometime in early January. So we're not talking about a long period of time here, and we don't have the date yet because, again, it's just about board member availability, including the board member we're losing sometime in January. So that's all we're juggling here.
If it would be helpful to the board, I'm happy to brief that and file it.
All right, thank you.
And that would be helpful just in terms of, the milestones in your testimony where, as I was reviewing in preparation for questions here and also juggling our schedules. And again, just making sure we have enough hours, I would say, to adequately look over information and deliberate on a number of rules that have been before the board. So I appreciate your willingness to kind of work with us but also make sure that we get it documented appropriately with all the pertinent milestones that you had mentioned, Ms. Borchardt. In all this consideration. It's a very complicated rule, so I understand that there might be some details in there as well. So with that, and it sounds like legal counsel Ms. Sona will be able to kind of enlighten us in documentation. So that will be helpful for our deliberation. And I want to look to legal counsel. Is there anything else I might need to add in terms of timing and
Thank you, Chair Sweeney. No, I think Ms. Borchardt set out the general timeline. I mean, I'm sure Ms. Sona will do a great job of the details, but it's generally what Ms. Borchardt described. And what we were talking about before, I think we're sort of returning what that original timeline would have been. So I think we're okay.
Thank you for that clarification. So with that, I just want to kind of reset in my mind, and I appreciate Ms. Sona's questions of our takeaways for the board. And I think in your response to her question, Ms. Borchardt, is I just want to be really mindful and understand. So in your response to Ms. Sona's question a few minutes ago is it accurate to say you feel the elements as currently packaged in the rebuttal proposed rule are based upon modeling and assumptions and economic analysis that really fit together, that if we do like determine different languages in certain portions of the rule, that it will impact and may have collateral or unintended impacts to the overall consideration of like as the team has analyzed in terms of the cost benefits. Is that accurate? And if so, can you elaborate just so I can set it in my
Yeah.
mind here?
Yeah, I mean, yes, everything you said, as a summary of what I said, I think is true. I want to be fair to your process, to not necessarily be telling you you have to take the whole thing, right? So I mean, but like there are some things fundamentally EER. I just cannot. I mean, that is fundamental to our analyses, and it's fundamental to the program. So I highly recommend that you that you keep the inclusion of EER as a calculating factor for the true emission reductions that occur when you take electricity and drive miles with it. Yeah, timeline too. This program is about greenhouse gas emission reductions, and that from quarter 1, we are actually both crediting and deficiting. That means that the greenhouse gas emissions reductions start, theoretically April 1, but at least by the end of that quarter, right? Any change to that timeline means that we are doing less greenhouse gas emission reductions. And that also, for example, has the ripple effect for the credit market, right? When clean fuels enter our program in year 1 and are benchmarked against the year 1 credit, which has not dropped as much as it will in year 2. I mean, it drops 1.8% in year 1 and 3.3%, I think, in year 2. That is an incentive for clean fuels to come in early, because they'll get a higher differential between the standard and their CI of the fuel. So when we start thinking about just changing things, then anyway, so those are the assumptions that were built in all the economic models, right? Is that a certain amount of fuel would be offset in year 1. And when we start tinkering with that, then the credit market, the credit volumes, the balance of fuels, all that starts to become shakier and shakier. And I'm sure I could keep thinking of examples, but are you kind of getting a sense of what I'm trying to say, why it all works together?
Exactly. And I don't know if any of the other panelists want to chime in about maybe another example of an element of the rule that, like you were talking about the EERs as being critical to, the basis of the rule. Is there another major factor, Dr. Rasso?
I think I highlight several of these in my written rebuttal testimony, if I can still speak after being up here. I think a really critical one is the framework that's used for carbon intensities for fuels as a whole. In my direct testimony, I had a flow diagram of it. And it's very similar to how other states do it. And there are various proposals out there on how to change it. But I think that flow of how carbon intensities are assigned to different types of fuels, and when different types of fuel pathways can be used by certain parties, is really important to how the program functions. And maybe I'll just elaborate on that a little bit, because I think maybe this is a problem that hasn't really come up with but is a problem with various proposals that have come up, including the proposal to allow fossil fuels to have alternative fuel pathways, but also allowing the temporary tables to be used indefinitely. Is when you allow some fuels to be using an average value and some fuels to come in with an alternative fuel pathway, you actually skew the average. So the table values are based on averages, and in the temporary tables, we've taken some measures to make them more conservative averages. If you have clean fuels coming in under a clean fuel pathway because they have an economic benefit to do that, right? They can generate more credits if they have an alternative fuel pathway. And then you only have the dirtiest fuel providers of that type left using the default or table values. That is no longer representative of the fuels that are reporting under that average. So then the department is in a position where we either allow kind of not great greenhouse gas accounting to be occurring in the program, or we have to come back and adjust those values to be dirtier and dirtier. And that process can repeat until the table values are only representative of the very dirtiest fuels in that category.
Thank you for that. And I know I'm going to shift a little bit. You know, there's been a lot of discussion about the ongoing engagement and input from various parties and entities. And I know a couple weeks ago we had talked a little bit about it, but right now, as the rule is proposed, is there, and maybe this is a question for Mr. Vaughn, is there a specific, can you point me to a specific section in the rule where there that kind of frameworks that and identifies if there's the advisory committee, whatever that is, and what are the and is that adequate? Is that adequate as we go forward in terms of in how and maybe provide us if you feel like it's adequate, provide us the board. I know there's been some discussion about it, but just trying to get my head around that concern that's been brought up and making sure that the rule allows for that engagement of various entities and parties, whether, you know, just as things evolve, as the regulatory world revolves, as our economic world evolves, and as the market evolves.
Sure. Thank you for the question, Chair Serena, members of the board. Yes, I certainly do believe that the periodic review section, I think it's 601, that really is about making sure that there is a continued effort to solicit input from people who do the real work in this industry to make fuels and bring them to our state. So I think that is absolutely critically important, and we certainly respect that and want to ensure that that advisory committee is providing that service to us. I think it blends, your question blends a little bit into the implementation side of things. And really, I think the most important part is I think we've set the bar pretty high in terms of what engagement means throughout this rulemaking effort. And, you know, as I mentioned just before, we've built a lot of relationships and with people who make every type of fuel that you can imagine, bizarre fuels that are on the fringe, you know, and people I think understand that they have access to the Bureau. We've made that very clear on our website. We've continued to make that clear in any setting we've been able to. And there have certainly been different members of the public and different parties in this rulemaking who have taken advantage of that, who have, you know, sent us emails and tried to just understand how to get involved in this program, what the program's impact could be to them. And so there really is no intent from this team to close that door. We want to keep that going. And, you know, as part of the regular reporting, I think that's required through the DMS, there's also the opportunity to see what people are doing, right, in the market. It gives us some insight into what individual companies are doing. We have access to their contact information. They have access to ours. It makes a real connection between real people to be able to pick up a phone or send an email and try to troubleshoot problems. And so I think that, you know, just from the implementation side, I think there's a real desire to continue this level of engagement as we move forward. So I would welcome any responses from my co-panelists as well, but that's what I have. Thank you.
One of the positions in the org chart that Dr. Rosso shared, we actually have 3 branches within Climate Change Bureau, and the primary branch for the Clean Fuel Program will be under Dr. Rosso, but there's also another branch which we call Community Development and Engagement, and we're hiring a marketing coordinator. It's Exhibit 131. A marketing coordinator. It's one of those positions that we have requested. We have a candidate. We're just waiting for them to be hired so we can start with them. Anyway, and so this is a new turn for us to have. If you look at all these, we're mostly scientists, and I won't be able to say we're either scientists or economists. We're also marketers. And the purpose of this position is, I think, also addresses your question, which is it's not only the marketing or the answering the questions from the participating parties, but also, I think it's really important that the public start to understand how these programs benefit them. When they go to buy a car and they get a cash on the hood rebate, they may have no idea why they got it, or the kinds of health benefits that come from a rule like this. So we really do see it our responsibility to go beyond just making this program function at its bare bones, but also to make sure people understand its value.
Thank you. I appreciate that reference to the exhibit, and I do see the marketing coordinator on there, so I appreciate that, and would also encourage, as the rule gets implemented, because it is so complex and there's many pieces to it, that ongoing engagement be a priority in the implementation, because I think it's going to be, just like you can design something as well as you can, but it's the implementation or the building of it and the execution of it. So that is also very important. With that, Madam Hearing Officer, I don't have any other questions.
Thank you very much, Madam Chair. On the platform, Member Honker, do you have questions of the department panel?
I greatly appreciate my fellow board members' questions, and I also wanted to echo their compliments to this panel for their work and their flexibility as this rule has gone along, and I have no further questions.
Thank you very much. Do we have Member Bitzer with us? No. Okay. Is there any reason not to excuse this panel then? No? Thank you all very much. Ms. Borchert, Dr. Rasso, Mr. Vaughn. Ms. Sona, I'm not sure that we yet have you already now have a preview of the discussion I was going to have with you, that it appears we're going to have a brief window sometime in the first half of January for a day of deliberations on this record. But I don't think we know what day that is yet. We do not yet know what day that is. As I understand it, it will be between January 5th and 13th. Is that?
That's our window of what we're looking at.
Okay. So it raises the question, certainly, of the more robust written closing argument and post-hearing submittals that y'all would ordinarily be used to. Do I understand that we will get the transcript around November 26th?
Yes, Madam Hearing Officer. Our understanding is that Mr. Lee is doing his best and committed to getting that to us by November 26th.
All right, thank you.
And Madam Hearing Officer, I didn't quite catch the date window that you said, January 5th to
January 5th to January 13th, but we don't know what day in that window they would actually be able to deliberate. We just know that that's the window. So
May I ask, with that, we sort of have a soft order, I guess, if you will, from our pre-hearing conference about filing closing statements and statement of reasons and things like that by December 8th. It sounds like even with a January 5th date, we might be able to get through at least one holiday and closer to the end of December in filing those. Is that a date certain that we can set today and have it in order so that all of us can plan our next month to make sure we know how much time we have to contribute a robust closing for the board?
yeah, so December 26th, which would be 30 days later, is the day after Christmas. That might be inhumane. What about the 29th or the 30th? That's before the 31st, which is New Year's Eve. But it would be a full month plus a couple of days minus the holiday, if that's a holiday you celebrate. The 29th is a Monday. The 30th is a Tuesday.
May I take 5 minutes to briefly run the window through my calculator to see if we have back-end problems that this discussion would benefit from?
Sure. And Mr. Mullenberg, did you have something?
Yes, thank you, Madam Hearing Officer. First of all, I appreciate that we'll have time to do this, as we've been in scramble mode to try to get this done by the 3rd. Just taking a brief look at the calendar and given where we're at and the holidays and everything else, and I would add that I appreciate the comment from one of the board members, I believe, about the board having a little more time to really deliberate on this issue, because it really is a very dense technical issue. And I think I appreciate that, and my clients appreciate the opportunity for the board to really devote the time to really meaningfully deliberate on this. I was going to suggest perhaps a date before the holidays, and maybe even around the 19th or the 21st. I mean, I think we could be flexible, but I would just add that, that would maybe not maximize the time we all have to prepare closing arguments, but it would also allow the board a little additional time to review what's probably going to be a whole lot of filings and paper. That's all I have. Thank you, Madam Hearing Officer.
Thank you very much. The 19th is a Friday and the 22nd is the Monday of Christmas week. Mr. DeSalen?
Thank you, Madam Hearing Officer. I just want to pretty much second what Mr. Mullenberg said. We are, as Chair Sweeney said, we are counting the hours at this point to get these briefs done. So the extra time would be very much appreciated. I think our preference would probably be later in the month. What Ms. Sona suggested, the 29th or the 30th. But any extension that you can give us would be very much appreciated. Thank you.
Thank you. Ms. Sona, anything else?
Thank you. I am flexible to accommodate the board's desire for length of time for them to be able to review what we submit versus the length of time for the parties to prepare. My look is that this would not impact an April 1 effective date. I can say more if you want, but I know there was interest in me not saying more. So just that conclusion, we still look on track.
All right, thank you for that, Mr. Noyes.
Thank you, Madam Hearing Officer. I just wanted to concur with Mr. Mullenberg on the date side. I just find that it's nice to have deadlines earlier so you get it done beforehand. So thank you.
Merry Christmas to us all. All right. Great. Thank you. So let's leave it this way, that it won't be before the 19th or after the 29th. And I'll send an email when we know the date of deliberations, because if it's the 5th, we're going to have that earlier rather than later. That gives the board 1 week to look at presumably a dozen submittals. So that doesn't seem long enough. But if it's a week after that, then we have a little more time. Is that all right? Okay. Thank you all very much for all of that. Oh,
Request to.
yes.
Are we done with that?
Yeah.
Okay. I just have one request. You shouldn't have opened the door at the end of direct with things I wanted addressed. This is wide open now. But I brought up the issue around 604 C2E in Ms. Borchardt's rebuttal testimony about, recouping costs of enforcement. And
Is this board member Ely?
This is board member Ely, David. Yep, sorry.
Thank you very much. Sorry about that.
No problem. And because this has come up before and we haven't really settled on it, if you wouldn't mind briefing that issue in your closing, I would greatly appreciate that. Thank you.
All right. Anything else? Certainly want to thank you all for your professionalism throughout these 3 weeks. And we'll look forward to finishing up the whole process with you all. Thank you all very much.
Madam Hearing Officer.
Who's this?
This is Yannick Suris with the RNG Coalition. Just a point of inquiry. Just because I've heard a few dates. So what do we have a final date of when we should submit closing statements?
No, so unfortunately it'll either be shortly before Christmas or shortly after Christmas. And the exact date will depend on when the chair is able to nail down a date with the other board members as to what date they'll deliberate.
Understood. Thank you.
And I will send an email. Thank you all.